তেরোশোটা possibility রয়েছে, বুঝছেন? Yes, Senator.
Yes. May I mention item number 39, my lord? I want to do it as item number 1 in view of the fact that the convict's father has expired on 19 March and for large ritual rights, I filed a petition, my lord. If your lordship allow me to move it as item number 1, my lord.
Move it just immediately after the motion.
After divorce. Deeply obliged.
May it please your lordship? May it please your lordship? Lordship, I beg to mention item 23. Your CD is not there. Lordship may post it after view vacation, lordship. 23.
Yes,
The
what is the
vacation?
position?
23, my lord, I have received the report, my lord. As per report, my lord, no case has been registered against the present petition. Normally,
Then it can be disposed of.
it was no case pending.
No case pen.
Then in that case, lordship, let me take instruction from my client. Then let it come day after.
Why?
tomorrow.
Why? What is the reason? Why?
Lordship, because
You have obtained an interim with a apprehension that there may be a case registration of the case. In that case, you may be arrested or whatever. We have given interim protection. Now there is no case. So in that
Yes.
case, why you need your instruction from your client?
is sitting before Tahane বুলি কৈছিলে.
Item number 23, I think, na?
It is 23, lordship.
That's the song did and account. So that is a keyboard and it additional pay on. The report received from the concerned police station of Dispur, ni? Which police station it is? Lanka.
Yes.
And
A WT message is received from Lanka police station, wherein it is reported that no case has been registered against against the petitioner Bonamali Nath at Lanka police station. In view of this, the present interlocutory applications is disposed of. The interim order passed as the present case stands vacated. However, the petitioner is at liberty to approach the appropriate forum in case of any registration case in the said case. With the observation, you are at liberty to file any case in the event it is raised.
yes, lordship.
This it will actually the message be kept at the party.
Lordship, another matter, item 36 be taken day after tomorrow, lordship, Friday.
36.
36.
Yes, what is it? 36.
36 is regarding little hearing will be there, lordship. It's for quashing of the affair, lordship.
So otherwise it is in order column. Is there
Yes.
any issue why it is in
No,
order
that
column?
only diary was called for. That was the issue. Nothing, no other order, lordship. 36.
Is any other respondents are there?
No, lordship. State is the party here.
State is only.
Yes.
Okay.
33.
In admission hearing?
Yes, lordship. Day after tomorrow, lordship.
Yeah, tomorrow is not possible. May not be possible.
Next week, lordship.
And you need after vacation will
No, it's a little artist. Prior, lordship.
Can copy of
first of April. First of April.
First April. Obliged, lordship.
May I please, your
Not
lordship?
Majesty soon done a council petition also had Mr. P. Bot. They have received the case diary here.
no.
Then how it will be fixed for admissions?
Scan copy of city was called for. This
Scan copy of CD was called for in that case.
investigation is going on. Probably. I will get the instruction if city required, I will have to copy.
Is the request made by MS Som, lays the matter in admission hall on 1/4. Yes.
May it please, your lordship? First, I beg to mention item number 19, my lord. Unless perhaps CD is not received, my lord. 19.
Are you on interim?
I'm on interim, my lord.
Sitting not received, issue reminder. It will be continued till next set of listing. Yes, Board.
On 29th of April.
Your blessing.
29.
May I please, your lordship, I beg to mention one criminal revision petition, my lord.
Make a mention before court number 8.
May I please, my lordship, I beg to mention item number 7. In this case, seeking 2 weeks time for filing affidavit. Concern the government also.
You are appearing for government advocate.
No, lordship, petitioner. We take consent from the government advocate.
Why you need that?
Lordship, not prepare the affidavit.
Affidavit.
Yes, lordship.
Government, whether government has already filed their affidavit.
Government file, we reply affidavit. We
You want
don't
to
file, we
reply?
reply affidavit.
With the consent of the others, it will consider the petition. That they need some more time while their affidavit in reply. And to the estimator, how many weeks you need?
This
How many weeks you need?
2 weeks, lordship.
2 weeks. You want any fixed date or after 2 weeks?
24, if possible, 24 of April.
24th of April.
Lordship.
24th.
Wait, please, your lordship, my lord. I beg to mention item number 8, your lordship.
8.
Yes, lordship. The
Yes.
connecting council is indisposed, your lordship. I humbly seek for adjournment, your lordship.
Who is your senior engaged counsel?
GJ Ahmed, lordship.
G.J. Ahmed. Appearing on the direct counsel appearing on behalf of Mr. G.J. Ahmed for the petition and submitted that he is not in a position to appear before the court as he, he submitted that he is indisposed according to paid for nature. Prayer allowed, the estimate accordingly. We are not fixing any date. After 2 weeks we'll do.
After vacation, it may come up, your lordship. Vacation.
Vacation date.
Lordship.
23rd of
Lordship, interim may continue. That's interim, your lordship.
interim be continued till next.
I'm deeply obliged.
Wait, please, Lordship. Lordship, prayer for listing 2 criminal petition, my lord.
Make a mention before court number 8.
Sir, I beg to mention item number 22, my lord. Let the matter be adjourned for the day, my lord. Item 22.
Yes, what is the position of 22? Scan copy we have received.
Yes, it is received, my lord.
Is there any interim question?
No interest.
The request made by Honorable Counsel Mr. Elstas for the petition. Matter is adjourned for a day. The registrable list the matter record. Adjourned for a day.
Highly obliged.
May I please, your lordship? I beg to mention item number 12, your lordship. Let the matter be adjourned for today, your lordship, as my learned senior is out of station, your lordship.
You are for the,
I am for the petitioner, your lordship.
have you informed the other side?
Yes, I have taken consent, your lordship.
Your good name?
I am for the petitioner, your lordship.
Your name is reflected here? No.
My name, your lordship, J. Bhuya.
J. Art Mr. J. Mr. K. K. Bhuyan, defendant counsel for the petition and with the consent of the other side, the paid for nature, prayer allowed. List matter accordingly to include other things. After 2 weeks we'll do or
Your
you
lordship,
need
can it be 30th?
30th of what?
This month, your lordship.
No possible.
After Bihu, your lordship, 22nd.
Okay, 22nd. Is there any?
Yes, there is an interim, your lordship.
22 for interim be continued till next year. Yes, Mr.
Wait, please, your lordship.
Oblige you.
Regarding item number 32, scan
30.
copy of TCR was called for. That has not been received. And service report in respect of respondent number 2 and 3 is also awaited, my lord.
2 and 3 are still awaited.
Still awaited, my lord.
Heard Mr. S. now still unresponsible for the petition. Also heard Mr. Keyboard on a petition BP agreeing on behalf of state. It is submitted with Mr. Nawaz that the service report of or on respondent number 2 and 3 is still awaited. And this scan copy of the TCR is also awaited. The registry will issue reminder in calling the TCR, list matter and the service be awaited. Service for the respondent number 2 and 3 be awaited till next set of listing. List matter, yes, and it did.
My lord, any fixed date, my lord, as per your lordship's convenience.
21 to
Ma'am,
first,
I'm
20.
deep.
Are you, is there
No,
any?
no, no.
May I please your lordship? Lordship, I beg to mention item number 30.
30.
As my senior could not come to the court due to some medical issues, your lordship.
Being on the learned counsel for the petitioner. Paid for enjoyment sitting at 33. The NPS council has some medical issues. Prayer out. This team at accordingly up to 2 weeks as on a date to it's by this.
Obliged.
May it please your lordship. Item number 24, I have inquired, CD has not come. The
24.
24. The interim order may be continued.
Yes, Botakur, where
Yes,
is the
city
position?
not received, my lord.
24.
24, yes, city not. received.
City not.
On
You are injured.
interim, on
City not.
27th.
City not received. Issue reminder.
Okay.
Interim be continued till next date of listing. Yes, when? 20?
27.
27 4.
Separate.
May it please your lordship. So the petitioner is in custody for 8 months and 16 days.
8 months and 16 days.
And the allegation, my lord, is outraging modesty of a woman. My lord, even if your lordship will find the FIR at page 12,
Yes.
may I read the FIR, my lord?
Hmm.
With all due respect, I beg to state that on 7/7/2025, at around 6:30 p.m., while I was alone at my house, without permission, the accused person, so and so, in the absence of my husband, entered the house and proposed that I have sexual relations with him. And getting scared, I asked him to leave, but he still does not leave the house. And he tore the clothes that I was wearing and outraged my modesty. Then, as I made hue and cry, after which the boy, namely so and so, fled from the house as soon as my son and husband came into the house. My lord, even if we assume these allegations are correct, my lord, for this in these kind of cases, my lord, in my respectful submission, this is not a case where the accused needs to be in custody for the entirety of the trial, my lord. He's already been in custody for 8 months. Charges have been framed, and your lordship will kindly come to page 33.
Yes.
Yes, ma'am. This is a charge order. Your lordship will see this charge was framed on 27/2/2026. And the last line, your lordship will see, case has been fixed for evidence on 25/2026. So while the accused is in custody, even then, my lord, the date for evidence has been given after 3 months, ma'am. So this is going to
And
lead
as
to
per your information, is there any evidence recorded till date?
no, ma'am, because case is fixed on 25, my lord, for evidence. And that will be the first day of evidence.
What's a 25?
5, my lord. So February charges framed and date is fixed when the person is in custody, my lord. Already 8 months, my lord. So for this offense, perhaps, my lord, further detention may not be necessary.
Well, your lordship may from the same page, my lord, page 33, my lord. While learned trial court my lord, rejected the bill. I have perused the case record. Record shows that charge has been framed against the accused under section so and so. Neither the victim girl nor any other witness is examined till date. Considering the nature of offense and early stage of trial, I do not show because victim was also not examined. Regarding my lord, date, that can be a my lord after receipt of the scan copy, my lord, for early disposal, my lord. That is a he can file appropriate application for my lord.
Do you think that is there any, probability of or tempering, especially the victim, because she is a major woman and a
Major
married woman.
Yes.
If I go by the FIR only,
Yes.
not by the otherwise, 8 months is already in custody. Otherwise, if you see the nature of the case also,
Yes.
probability of tampering with the evidence of the victim may not be there at this stage, as she is a major married woman.
Yes.
Heard Mr. S. Lamas, the learned counsel. Heard Mr. P. Botakur, the learned additional PP, if we want to respondent, application in connection with this. It is submitted by Mr. Lamas that the accused petitioner is in custody since last 8 months, 16 days. Until date, no evidence has been recorded in the sequence. Mr. Navas further submitted that from the plain reading of the advice seen that is this case of outraging modesty of a woman. However, the charge was framed, this case on 27/2/2026, and the the state of evidence is from 2005-26. That is after 3 months of the 3 months, though the case the petitioner is in custody. We submitted that the petitioner is a permanent resident of his address and will appear before the learned trial court below, and then when the case is fixed. There is no chance of it. Mr. Watt, he done it FPP, his objection and submitted that his other bail application was rejected by the learned session judge Malbari, considering the nature of case and also considering the fact that the evidence of the victim was not recorded. Mr. Watt accordingly insisted to call for the scanned copy of the DC. Next, hearing the submission made by the considering all aspects of the case. Vis-a-vis the length of detention already under by the accused petitioner. This court is of opinion that further custodial detention may not be required for the purpose of review of this and the deputies. It is session judge Nalbari.
Session Judge Nalbari, madam.
To the satisfaction of session judge Nalbari. 30,000 video with 1 CB.
No, just one correction, my lord. 27/2/2026 order shows that charge has been framed. It is not the date of framing of charge. That was earlier, my lord. This order, my lord, 27/2/2026, it only shows that charge has been framed. It is not the date of framing of charge. Charge was framed earlier, my lord.
To charge frame probably. Like one change where the charge has already been
Okay.
framed prior to 27/2/2026. The date of evidence is fixed only on 20/05/2026. That is 3 months. 3 months after the date of order passed on 27/2/2026. So line to one milai.
Deeply obliged. May I please, sir? Well, this case was reached. This is an application under section 483, Your Honor. The case was registered under section 303,
303.
Your Honor. My lord, kindly have a look at page number 14, Your Honor. In this case, Your Honor, the alleged article already recovered, Your Honor, from the possession of accused number 2, Your Honor. So I am here accused number 2, but the article was recovered from the accused number 1, Your Honor. So I'm behind the bar already 10 days, Your Honor, till now. So
Since when you are in custody?
16, from 16 March.
16th of March.
Yeah.
As per you, all the materials are, recovered.
Yes, Your Honor.
How can you see? Where is the seizure list?
Seizure list is, Your Honor,
Seizure list is not annexed. No?
Seizure list?
20,
Not-
Your Honor, page number 20.
20 years.
20. These are name of the
Solar panels.
Solar, for
solar panel.
actual fact is that, Your Honor, kindly have a look at page number 5 and 6, paras 7 and 8, Your Honor. Your Honor, may I? The police has seized 4 number of solar panel from the accused number 1, which is most probably purchased from Gauhati from his household needs. It is pertinent to mention here that the present accused petitioner have no connection with the accused number 1. Moreover, the alleged solar panel already recovered from the accused number 1.
This is your
We-
submission. I can understand this is your
Yes, yes.
submission, but where is your forwarding?
Forwarding
Page 14, my lord.
14. Forwarding is 17 and 18.
Page 14 is the FIR, I think.
No, sir. Is it 17 and 18?
17. Yes, 17 and 18. They were caught red-handed. 4 numbers of.
They were caught red-handed.
Yes,
As per the grounds of arrest, they were caught red-handed.
red-handed.
Actual fact that
Those were recovered from their possession.
this present request petitioner was going to Sizubari bus stand along.
See, these are your submission, but
Yeah.
as per the forwarding report, you were caught red-handed. So let us see the case diary that apart,
Yes.
he is in custody since 16th June.
Your Honor, since the articles already recovered from, so
Let us see. Yes.
On 6th of April, my lord, I can produce this.
short
6th
date,
of April will
Your Honor, short date maybe 31st or 6th.
7.
Hatika police station, Your Honor.
No, whatever. We don't have date. 5 and I'll not keep. Is there any date?
My lord, 5, my lord, Sunday.
Monday, 6th is a Monday, na?
First and second already many cases are
Many cases are
fixed.
6%, second, 5.
Second, first of
First, but yes, first, at best, first can be or second.
Yes. I will try first of April.
First. City,
Please, your lordship.
yes,
Lordship, co-accused bail is fixed on 33/26, while
yes,
co-accused bail application is fixed on 23/26, while VA number 771 of 26. Under such, our
23 is already gone,
30, sorry,
33,
33.
co-accused bail application. Okay, then same, out of same FIR?
Our case may allot on same day, lordship.
Yes, it's what.
Sorry.
All for the case then, is the matter on
30.
33, 2026. Along with, yes, other case number, just tell us, the case number, other case number,
Itu case number one.
Case number.
the case number, other case number,
Other case number is lordship 771 of 26.
771
Yes, BA.
of 26. BA or
BA, BA, lordship.
BA 771. We are listing
Okay.
your matter along with 77.
Yes.
May I please, your lordship? Not a report was called for, my lord, whether any case is pending against me or not, my lord.
Oh,
Report was called for, my lord.
There is a note, my lord, as per verbal instruction, my lord, no case yet registered. As per verbal instruction, so I will get a written report. My lord.
verbal instruction may not be sufficient. Later,
My lord.
Yes.
uh, assess HA secret, the learned counsel for the petition also, but Mr. P. Bota, the learned petition PP. It is submitted by Mr. Bota that he received only the verbal instruction that no case has been registered against the present petition. And accordingly, he submitted it. He may be allowed some time to take the written or oblique proper instructions from the concerned police station. In view of this, let the matter when can be
On 31/3, 31.
31 will be this good.
I love this. Report.
Please, Your Lordship.
Yes.
Lordship, it's a English section is 87, Your Lordship, kidnapping, Your Lordship. FIR is page number 8, Your Lordship. Very short FIR, Your Lordship. The 11 portion is page number 12, Your Lordship. The victim is Major, Your Lordship, 22 years, and petitioner is a student, Your Lordship, 24 years, Your Lordship. There is a love affair, Your Lordship, between the victim and petitioner. Our Facebook, Your Lordship. On the date of occurrence, victim willfully visited my home, Your Lordship, with intent to marry me. Thereafter, called over the mobile phone to family member of the victim, and she was returned back, Your Lordship. Actually, both the parties have no objection if they are same religion, Your Lordship, but religion is opposite. That's why no marriage took place, Your Lordship. And
Okay,
FIR
but
is lost, Your Lordship.
recovery is there,
Yes, Your Lordship.
where from we can see.
She actually on 64 statement not given, Your Lordship, certified copy, but I in my para 3, Your Lordship, clearly stated.
Don't give you, but otherwise, is there any order of the court that she already been recovered? That much only we need to know. If she has already been recovered as per your submission, then it's okay. Otherwise, we do not know
Yes.
what is the stage of the position of.
FIR is first part missing, Your Lordship. Second sentence is বহু বিচাৰ কৰি জানিব পাৰো যে উক্ত পদক্ষেপজনে মোৰ ছোৱালীজনী পলুৱাই নিছে।
হয়।
Elopement, Your
পলুৱাই নিছে,
Lordship, not
ক'ৰবাত লুকুৱাই
kidnapping.
ৰাখিছে। That
She
means
is
we need only.
22 years.
No, yes is okay. Kidnapping part.
Any short date may be fixed, my lord, CD would be necessary, my lord. Otherwise, whether she recovered or not, my lord.
Or if you can
Yes.
place any order regarding her recovery,
Yes.
then it's okay.
Yes.
Will you be able to? We can list it very shortly,
Short
but
date.
that is required. Whether
Secondly,
any
Fixed on
order.
Friday, Your Lordship, I shall produce the order, Your Lordship, for recording her statement, Your Lordship.
Huh?
Order sheet, Your Lordship, I shall produce it, Your
No,
Lordship.
whatever, what kind of matter you can produce, or in the meantime, we'll call for a case diary also.
Lordship, Lordship, Lordship.
It will come because there is no forwarding, no order, nothing is there.
Lordship.
So we are not in a position to say whether the girl is recovered or not.
Yes.
That much only.
Lordship.
Otherwise, it's a case of anticipatory. I just do agree.
Lordship.
Okay. Yes, CDB call for. And in the meantime, the learned counsel for the petitioner, he also submit the
It's a Hazu
legally
PS.
papers of the orders, which would be relevant for the presence. Is it liberty to file, can submit any relevant papers of the orders which may be relevant for the present. Can we like it or when it can?
On my lord, 6 of April, my lord. Otherwise, AB, my lord, he will not be arrested.
Yes, yes, no.
6 of
6th of
30 or 31, Your Lordship, Hazu PS, Your Lordship.
6.
No, 30,
Azul.
31 is okay. Many
There
matters
is-
are there, must be not 30.
31, Lordship, 30 or 30.
31.
Okay, somehow we are giving. 31.
Lordship.
Only motion takes. Itu mati dia.
Upgraded item number 39.
May it please your lordship. The petitioner Hitesh Kakoti, my lord, he has been convicted for 10 years and fine of rupees 5,000 under 376. I have stated in paragraph 7, my lord. During this period, my lord, his father expired on 19 March. May I pray for 15 days, my lord, so that I can do my rituals. After 15 days, I will surrender again, my lord. And the main bail application is also been pending, my lord. I'm not arguing on marriage. Because on marriage, my lord, the affair has been lost by a married woman after 5 months. I'm not arguing on marriage, my lord. Only because of last ritual rites. my lord.
Your the petition for suspension of sentence is IA 142.
Yes. And
uh,
this is 325, my lord.
325. Is there any document you have submitted here?
No, my lord. This has been a statement on record, my lord. The affidavit has been sworn in by the wife itself, my lord.
Wife means his mother.
Uh,
Who died? His father.
Wife of the accused, my lord. He is also married, having children. The
No,
affair,
who died? Who died? His
this
father.
petitioner, petitioner's father,
Yes, father. Affidavit is sworn by his wife.
wife, Vivha Kakoti, my lord. And this is matter of records, my lord.
How he died? On 19.
He dies of old age, my lord. Old age, my lord.
Is a case of 376.
Yes, yes.
Or POXO is also there. No.
No. She's a married woman, my lord, who lost an affair after five months, my lord.
Yes, but special consideration.
Yes, my lord. Otherwise, I would like to leave it to lordship regarding for 15 days because otherwise difficulty is that my lord, again someone other will come by considering it as my only within period of 15 days, my lord, or
He'll surrender, my
he will have to surrender, my lord. Otherwise,
Yeah, it is very difficult. In some cases, when
yes.
I was the district judge also,
Yes, but that
we
is the
find many
difficulty.
cases wherein definitely on the humanitarian ground or
Only
this
for-
kind of situation
Mine.
we allow. Subsequently, they did not surrender. That is the
Oh, didn't surrender.
And on
Yes,
that
sir.
day, my lord, no extension application
And if
will
your
shortly
lordship,
after can be allowed.
that depends, my lord. Here in this case, my lord, we'll kindly see. Judgment is 9/7/25. And since then, he's been behind the bar, my lord. There was a delay in filing the appeal. Delay condonation petition was there. All along during the trial, he appeared. He have his wife, he have his children also here, my lord. And on merit also, my lord, I'm not going to the merit. There is merit in the case, my lord.
This will come, okay, subsequently will come.
Mainly NDPS case, my lord, they flee away, my lord, if these outsiders and all.
I criminal 325 of 2000. Part mistake.
NDPS पे किधर खोल रहा है वकील resident answer
This interlocutory application is filed.
खोला ले main bail
For,
application पे ना लिखा है
paying a bail for 15 days for the convict petitioner only to perform the last rituals of his father who died on 19/3/2026. Mr.
कोई
Priya
दिक्कत
further
नहीं?
submitted that
14 days और बिना
by
surrender करो
given judgment and order dated 9/7/2025 filed by learned additional session judge FTC Rongia in sessions case number 22 of the 2019 sentenced the present applicant to undergo arrive for 10 years and to pay fine of rupees 5,000 with default stipulation for convicted section 376 IPC and another period of 1 year for the sentence for the offense committed under section 1506 IPC. So Mr. Tia further submitted that during the entire trial, the present applicant appeared regularly before the court and the contested the case. However, since the date of judgment, that is on 9/7/2025, he is in custody, and for which another interlocutory application has already been filed, which is registered as I Criminal 142 of the 2026 for suspension of sentence and for releasing him on bail, but only on some special consideration. But on the special ground, the present interlocutory application has to be filed only seeking bail for 15 days to perform the last rituals of his family. Next one, Mr. Bhuyan, for the submission, there is no any document to submit it to in support of the date of his father, but who died of old age, and the wife of the present applicant has sworn the affidavit stating that the father of the applicant died on 19/3/6. He further submitted that he being a permanent resident of his address locality, there is no chance of absconding and will surrender within 15 days before the jail authority after performing the last rituals of his father. Next part, Mr. Board of the Learned Additional BP submitted that the even if the petition for the present petition may be considered, but there is a probability of absconding of the accused applicant if he is released on bail for 15 days, and hence he submitted that there may be some strict conditions for strict conditions even if the petitioner is granted bail, considering this special. Next, but during the submission made by an considering all aspects of the case, without going detail into the merit of the case, only on the humanitarian ground, the present petitioner is allowed to go on interim bail for 15 days. On 15 days, on furnishing a bail bond to the satisfaction of the Court of Additional Session Judge Rongian,
Wrong here, my lord.
Session Judge Rongian, for rupees 50,000 with 102 lakh. And with a further direction to surrender before the superintendent, no, before the superintendent, jail superintendent, on or before completion of the 15 days. In default, the interim bill
Wrong here,
and
okay.
petitioner will automatically be transferred. Okay, for 15 days, we are granting. Within 15 days, you have
My
to
lord.
surrender before the superintendent of jail.
Deeply obliged.
Okay. Jail is settled. So the jail superintendent will also furnish the order of compliance before this court date, before this court.
Let it be pending, we'll furnish it, my lord.
Yes.
We'll, my lord, comply with the order by furnishing his surrender order.
Comply with
Yes,
the comply order. So
deeply obliged.
yes, otherwise criminal appeal is there. We have received the case.
Another miscase is there, my lord. I'm not arguing that today, my lord.
It were issue to be open.
একটু বলবো তো তার নাকি মনে হয়।
Heard appeal to heard Mr. Evian, the run petition also heard Mr. Evian. The run additional PP appearing on the state. CD already, no, TCR has already.
No objection, identified for it.
Appeal is
Appeal to.
admitted.
Hmm?
Admitted this and it is. Appeal is already been admitted. List the matter for final hearing. After 15 days, can we fix a date
Yes, my lord.
so that compliance can also be, the hearing date?
IA is also there already.
Yes, it will be listed for final hearing.
Can copy also receive.
28 of it.
Yes.
It will be 15 days. After 15 days.
Let it be on 28th of April, my lord, because from 31st March, I won't be available, my lord, till 28th, my lord, of April. So
But
let it be 28th April.
Surrender before the jail authority.
Yes, yes, he will surrender, my lord. So far interim is concerned, my lord, absolutely, my lord. He will obey, my lord. Obliged.
It will dispose করে আইটো এটু কানে আর ক্রিমিনাল অ্যাপ্লিকেশন এটা interim.
May I please, Lords. Here in this
15 my lord page there in 15 my lord CD not received.
two times your call for CD, your Lordships. Very unfortunate, CD has not been come. Why the IO has not been sent the CD? In this case, 41 days behind the bar. So arrest on your Lordships, 12/12/12/2026. Your Lordships, under section 87 allegation. In this case, you see FIR page, your Lordships, 9. Is the FIR? May I read?
No, reading is will all right. What is this recovery? Is there any recovery?
Recovery already on the day of day of arrest. That the victim girl has already been recovered. As per FIR, clearly stated. May I read, your Lordship? With due respect, humbly begs to state that on the day of such and such at the evening time, the above mentioned accused person with very cleverly eloped with my sister, namely Khairun Nasa, aged about such and such. From my house, Hajo, Hirazani, it is to be informed you that the above named accused person is a married person, have a child along with his wife in his home. After the incident happened, we charged everywhere. And after the conversation with the family members of the accused person, his father handed over of the accused person along with my sister before Mukalma police station. And now both of them are there. This is the FIR content. As per FIR, the victim girl as well as the accused person handed over the Mukalma police station. On the day of arrest, as now, 41 days.
The
In this,
victim is only 16 years and the accused
That is
person
the main
is
concern.
married person. Madam. So I will get the instruction whether if any POSCO section also added or not. Madam.
That is the only aspect. Otherwise, it's okay. As per you,
Yes,
we are
Lordship.
recovered. But POXO, possibility of adding of POXO is very much there.
Because victim
Because,
is
but-
only
because
16
if you
years.
go by the FIR also, it is lost only on 11/2 and the date of incident on 8/2, only after recovery. So, but
Yes.
2-3 days where they were there, whether any physical relationship was there, that is we are not known. That is the meaning. Why? But why CD is not there?
Your
Your
Lordship,
Lordship, my lord,
POCSO can
Your
be
Lordship may fix it on 31st. Madam. I will get the CD.
CD not received, should remind list matter on 31/3/2026 with a direction to the IO to
This is the
send
last
CD
chance.
on or before the next date of listing without
Last chance will be given, Your Lordship, third times.
strict direction already been given.
Yes. Allah bless.
16 TCR is there, na? TCR is already there. Why it is again here? Here this is মানে মই বুজাম earlier application reject.
May I please?
তাতে মই আগতে dispose কৰাত কৰবাত তেনেকে আছে। কোনে লিখে? Yes, have you gone through the record? Yes, you can, sir.
Maybe Ships, the case has been charge sheeted on 22/3/2025. FIR was dated 24/10/2024.
Charge sheeted when?
22/3/2025.
25.
25. Therefore, FIR was dated 24/10/2024. After 150 days, I mean, within 150 days, police has duly submitted the charge sheet. Now, coming to the point, Your Lordship, after filing of the charge sheet, court has issued summons to me. I've received the summons, and thereafter, having due diligently knowledge that I don't have any involvement to this case, I went to a learned advocate in the concerned court below. Then I appeared to the court as per the summons. Court listened to my pleadings and my submissions and arrested me on the ground, section 37 of the NDPS Act, because the FIR contains 22C, Your Lordship.
So you were earlier on bail.
I was never
Absconder.
arrested, Your Lordship. I was
You were
portrayed
absconded.
as an absconder, but I was not involved in the case. I will come to that fact, Your Lordship. But first, I want to clear the point of law, Your Lordship. That due to section 37 of the NDPS Act, the learned trial court below,
Now, since when you were in custody?
since 26/5/2025.
26.
It is more than 300 days, Your Lordship. I have surrendered myself, Your Lordship, because I have no involvement. My learned advocate below also suggested me to go for an anticipatory bail, but I did not took that option, and I went to the court to place my case because I am not involved in the case. And hence, I most humbly pray to allow me to go on bail. Investigation is not required, Your Lordship. Case is already charge sheeted. I'll
No, but
cooperate with
this
the
is, but this is not the likewise the other cases. Unlike other cases, it is bail cannot be considered unless 37 is there, na?
Indeed, Your Lordship. All the other co-accused, there are 3 numbers of accused who were arrested and forwarded. According to the charge sheet, Abdul Samad, Salimuddin, and Fazil Ahmed. Now, Your Lordship, I have no connection with these 3 persons. Coming to the point, these 3 persons are also on bail by the learned trial court below. Therefore, Your Lordship, I most humbly establish the point of parity, Your Lordship. Doctrine of parity, Your Lordship. Now, coming to the ground of doctrine of parity, I want to establish that versus state of UP, Your Lordship.
Before I mean, submitting any
My
statement and
facts.
all, you just
Fact.
knew how
Absolutely,
the
Mr.
ground of
Fact.
parity can be entertained here. How it is a parity? On one hand,
No.
you are saying that you are not at all involved. You are not known the other co-accused persons who were already granted bail due to many reasons. I don't know what is the reason. So now, what is your ground of parity? Parity has to be there some ground, no? To
Your
consider
Lordship-
your ground of parity. What is the ground?
Oblige, Your Lordship. Page
How your
number
case can
5
be
of my
considered
main
on the
bail.
same footing?
Sorry, Your Lordship.
Sometimes it happens that in a car, 3 persons are there, their custody, some contraventions were recovered. If 2 persons or 1 person is already been, the ground of parity may be there because under the same circumstances, they were recorded and or caught behind. But now your question is that you are not at all connected with the case, you are not known to the co-accused person. So how ground of parity can be entertained at this stage?
Yes.
What is your submission in that regard?
I would like to take your Lordships to the FIR. That is at page number, operative portion, page number 16 and 17, to the main bail petition.
Yes.
Your Lordship, the FIR, they have, as per the FIR, there was an auto, and the auto was like hold as per the ambush of the police. And as per the reliable sources to the police, there were 4 persons in the auto. On the place of incident, at that moment when the auto was stopped, the other 2 accused persons escaped as per the FIR. Then, Your Lordship, 2 persons were on spot interrogation. They uttered my name, that I was one of the person who escaped. Your Lordship, this is the FIR in brief. Now, coming to page number 5 of my bail petition, Your Lordship. Page number 6, Your Lordship. I've clearly, categorically stated there in paragraph number 6 that, Your Lordship, on the same date of FIR at around 12:30, that is also at around, Your Lordship, I'm not pretty much sure about it, it's blur. One of the co-accused, Salimuddin, called me. The reason is all the 3 arrested accused persons and me hail from the same village. And the name of the village is South Bandarkuna, PO Irarigul, PS Patharkandi, Sribhumi. Now coming to the point, Your Lordship, I received the phone because, Your Lordship, I'm a reputed person in the village. I do lots of social works, including in condiments with the village headman. That person, he called me to have a meeting regarding some social issue. He said, Your Lordship, if you allow, I may want to use some vernacular words here. He said, Ahiyasu, meeting at a koribo lagi. Therein, after, Your Lordship, what happened? I was waiting for them to host them. And I have no knowledge that they were arrested in that place, nearby Irarigul APBN spot. Thereafter, what happened, Your Lordship? I forgot about the incident. When I received the summon, then I came to know from the village headman that those persons were arrested on so-and-so date. And after going to the court, connecting to the advocate below, I got to know that under section 180 statement, somewhere they might have mentioned my name. And therefore, I got the apprehension that now I will be arrested because this is a drugs case, including commercial quantity. And then I appeared to the court.
So you were not there in the auto?
I was not there in the auto. I was not, police has not found anything from me, not
No,
arrested
not
to me.
because you fled.
I did not fled away, Your Lordship. That is the case of the police, Your Lordship. And there is a matter of trial, Your Lordship. Trial may be given to me. I will face the trial. If I am convicted, I am behind the bars.
Yes. So after receiving someone, when you appeared before the court? On
26, Your Lordship, it is annexure 3.
26/05/2020.
24.
Oh.
Page number 26.
Yes. Yes, Mr. Shah.
My lord, I have gone through the record, my lord, trial court record, my lord. First of all, his strength is different, my lord. Sometimes he said that he do not know about the other co-accused. Sometimes said that one of the co-accused called him from the same village for a meeting. That is, my lord. But origin facts is that, my lord, 4 of them, my lord, in an auto vehicle, my lord. And when there is an ambush by the police party, my lord, two of them apprehended and two of them fled away. And two of them, one of he, my lord, present petitioner, my lord. From the statement, it reveals, my lord, during the investigation, he is not cooperated, my lord. He is not participate in the investigation, my lord, and that's why he was declared absconder in the charge sheet, my lord. And from the statement of the, my lord, other the co-accused, including, my lord, it was said that they have parcels from Mizoram, my lord. Mizoram, all of them, and on that day, my lord, they are coming to sell, my lord, the drugs contraband to the person, my lord, but somehow police has apprehended two of them and two of them fled away, my lord. And the present petitioner is the, my lord, one of the person who has fled away from the, my lord, auto vehicle, my lord. And here, search framed on 19/8/2025, my lord, against the present petitioner under section 21C and DPS, my lord. And next date is for evidence, my lord, 4/4/2026, my lord, in the month of April, my lord. And contrabands were found in positive, my lord, that is heroin, my lord, from their possession, my lord, from the other accused person, my lord. And my humble submission is that as all of them, my lord, carrying the contrabands, my lord, only 9 witnesses in the search sheet, my lord. At this stage, my lord, my objection is there, my lord, some of the material witness may be examined, my lord.
Your lordship, my learned friend is trying to say that a person he has to stay because only few evidences are there inside the.
My lord. And 9 witnesses are there, my lord. At least some of the material witness may be examined. After their examination, it may be considered, my lord. And lordship is well known, they are organized crime, my lord. All of them, my lord, coming together for sale, my lord, but somehow they managed to flee, my lord, from the auto, my lord. And the statement reveals, my lord, it is there, my lord. And they have purchased it from Mizoram, my lord. That is there, my lord.
Your lordship, police never came to search my house, never came to arrest me. I was living in the house peacefully at my village. And I know them, your lordship. My learned friend, my learned senior friend has told that I am telling I know them, I don't know them. I know them because they are my village head.
No,
Village
initially you said that you do not know them.
No, the
Then I seek apology to the statement. I don't want to press that, your lordship. I know them because they hail from my same village. But I'm not connected to the case. I was not present there with them in the auto, neither in the conspiracy, your lordship. Charge sheet has been filed. 37 rigors, my learned senior friend has very well objected, and I'm trying to very well establish a prima facie case that I'm not connected to the matter, your lordship. The twin test.
In the earlier 2 occasions, court will also rejected.
Yes, your
the
lordship.
ground that
I have
during the
annexed that.
investigation, they have not cooperated and absconded, and that's why it is rejected under rigors of 37.
Your lordship, annexure 4 and annexure 5 to my petition is very well annexed. The earlier 3 bail rejection orders, the day when I surrendered, the day next day, the next day, and nowhere it is says that I have not cooperated with the investigation. I was never arrested, your lordship. Only matter therein is that Section 21C, Section 37 of the NDPS Act, I've been projected as an absconder, rejected the bill.
Well, Mr. Rama, or Asur,
Assure, your lordship.
heard Mr. Asur, the learned counsel for a petition. So heard Mr. B. Sharma, the learned additional PP, appearing on the it's an application, section 12, scan copy of the DCL has already been received by justice. Next, it is submitted by Mr. Sur, the counsel for the petition, that the present accused petitioner is innocent and he is no way connected in the LS box. Nor nor there is any recovery from his position, from his position. It is on the basis of the statement made by the co-accused persons only. The case has been charged against him and charged against him. But during the entire investigation, police never search for him, and he is not aware about the case registered against him. If for some that after receiving the sum from the court, he appeared before the learned special judge on 26/05/2010, and since then he is in custody. His bail applications were earlier rejected by the learned special judge in 3 occasions, only considering the fact that he was shown as an absconder, the case is under the commercial quantity, and the rigor of, and also considering the rigor of section 37 and Mr. Sood further submitted that it is a fact that on the day of incident, he was called by one of the co-accused person who belongs to his same village, and on good faith, village, asking him for settlement of a issue, and on good faith he went to visit him. Subsequently, he came to know that the said person, along with one other, already got arrested by police in connection with the present case. As per the FIR, the contraband was recovered from possession of two co-accused persons who were found along with the contraband, which was carrying in a auto van. But this present petitioner is not at all connected with the alleged offense. He further submitted that the case has already been charged, and there is charged, and there is no probability of tampering with the evidence of tampering with the investigation at this stage. However, he being the permanent resident of this address locality will regularly appear before the learned trial court below, as and when the date is fixed. Next paragraph. Mr. We also submitted that two of the co-accused persons have already granted bail, and considering his case on the same footing, he may also be allowed to go on bail on the ground of fact. The next one. Mr. Sharma, the learned additional MP, submitted in this regard that from the FI itself, it is seen that there were 4 persons were coming in the auto van, wherefrom the entire contraband was recovered. 2 of them got arrested by police with the contraband, and other 2 persons managed to escape from the place of incident. And during investigation and considering the report of and considering the submission, considering the statement made by the co-accused person, it has come to the knowledge that out of 2 accused persons, one was the present accused present accused, and during the entire period of investigation, he never cooperated with the IO. In spite of several search for him, the police could not apprehend the present accused petitioner, and for which he had to be shown as an absconder in the charge section. Mr. Sharma further submitted that from the available materials in the case diary, it is seen that the 4 persons, including the present petitioner, were in the auto van, and they purchased the contraband or Mizoram from Mizoram with a view to sell the same in that locality. And during that process only, the 2 of them got apprehended by police with the contraband. Mr. Sharma further submitted that case has already been charged, and against the present petitioner, the charge is also framed on 19/8/2024, and next date is fixed for evidence on 4/4/2026. Till that, no material witnesses is examined by the prosecution to know the examination to know the involvement of the present petitioner, and accordingly he submitted that till the evidence of recording evidence of some material witnesses, the prayer for petitioner may not be considered at this stage. Mr. Sharma further submitted that considering the weakness in the case record, there cannot be any belief that the accused petitioner is innocent or will not commit any such offense in future to grant bail under grant to satisfy the twin condition of Section 37 of NPS Act. Mr. Sharma accordingly raised objection and submitted that this is an organized crime, and at this stage, a prayer for bail may not be considered. Next, para, hearing this submission made by learned counsel for both sides was failed to include that. And from the submission made by learned counsel for the learned additional PP and the materials from the case diary, it reveals that the present petitioner is privately found to be involved in the alleged offense, and he is stated to be one of the person who fled away from the place of incident at the time when the other two accused persons were apprehended by police along with from the materials available in the case diary, it cannot also be held at this stage that the present accused petitioner is totally innocent and will not commit any such kind of offense if he is released on bail. Case is registered under the commercial under the commercial quantity, and there is no reasonable ground to believe that the accused petitioner is innocent to satisfy the twin conditions of the 37. The case is at the initial stage of trial, and the case and the 4/4/2026 is the first date of fixing for evidence. Accordingly, I do not find it justified to pass any order on bail at this stage, only considering the length of detention undergone by the accused petitioner. In view of this, the present petition stands dismissed. Your petition stands dismissed.
Not allowed, Your Lordship.
Stands dismissed, not allowed.
The 17 and 27 may be taken up together. Well, same case there.
17 and 27.
27.
Yes, ma'am.
You are appearing on 17.
Yes, ma'am. 17 and both are.
Right, you are appearing.
Yes, ma'am. Well, at the present, well, at item 17,
Yes.
here, my lord, he is arrested, my lord, on 27 of February. Today is 26 days, he is behind the bar. FIR is page 9, my lord. My lord, here, information stated in the FIR that on 22/2026, evening at about 6 p.m., the below named accused person in a pre-planned manner, without any reason, carrying sharp weapon, entered into my house without permission and with the intention to kill, assault me, and injured me in various parts of my body. In this house, when my daughter so-and-so, and my wife so-and-so came forward to save me, then the accused number 1 attacked my daughter. As a result, just below her eyes, near the nose, she got cut, and rest of the accused persons attacked on 3 of us and moved this the outraged modesty of my wife. On hearing hue and cry, nearby people came and saved us. Hence the affair, my lord. But the fact is that he's developed the story, my lord. The story is this way. The informant was riding a motorcycle, and they're the neighbor, my lord. And the present petitioner, my lord, was standing, my lord, a bit far from the informant, my lord, and suddenly he came with motorcycle and hit the present petitioner. And they started, my lord, altercation, and debate also start. And suddenly, the informant gives slave the present petitioner, and he's a older person, my lord, than the informant. And he raised the question, why you misuse with me and you give slave me? Then, my lord, family member also come out, my lord, and both family member in front of the house, my lord, because road is in front of the house, my lord. And when both family member came, and there was a, my lord, altercation and debate also, my lord, and not such serious, my lord, incident was taken place, and they have used that they entered in the house. It is very false, my lord, because it is in front of the house, because roadside the incident was happened. And, my lord, the present petitioner, and he is 55 years old person, and he, my lord, called his uncle but suddenly give the slip, my lord, the family member came and raised the question, why you misbehave with such a person, my lord? This is the fact, my lord. And now, my lord, section here, my lord, the only two section is non-billable, that is 118, 2000, my lord, subsection 2, that is earlier 326. My lord, as per my instruction, 326 is not present here. And my lord, another section is non-billable is 374. Molestation, my lord, this is a public place, my lord, hold the family member. No such, my lord, the intention is 74 is present, my lord. So only kindly, my lord, examine the 118 of subsection 2, earlier IPC of 326 is present or not, my lord. Other section is the valuable here.
Case diary received, my lord. Two injury report also received, my lord. And one photograph of the, my lord, victim, my lord, cut injury below left eye, my lord. This is the cut injury left eye, my lord. Otherwise, nature of injury is, my lord, simple, may be caused by blunt object. Two persons injured, my lord, Noor Salima Akhtar, the present petitioner, and his father, my lord. After the incident, all these accused person entered inside the house and assaulted, my lord, the victim and both the victims. One is father and one is.
And is there any statement of such kind of
Yes.
incident and all?
Specifically, my lord, no specific allegation by the witnesses that this is the person who has specifically assaulted, but all these accused persons, my lord, and injury also, my lord, there are, my lord, injury to her father also, my lord, and they stated that all these accused persons, my lord, unauthorizedly entered and thereafter, my lord, assaulted.
No, it's okay. It is as per the FIR. I'm asking whether there is, as Mr. Uddin is submitted, is there any statement that there was a, I mean,
Regarding that, my lord,
the
FIR and
accident
his
and all these things?
petition there that there is some accident. So regarding that aspect, there is nothing in the CD. My lord. Only witnesses stated that they unauthorizedly entered inside the residence of the my lord, this victim is residence, my lord, victim, and thereafter assaulted. My lord.
Earlier fact is not disclosed. Directly FIR
And
started
regarding
that.
that incident, my lord,
But-
regarding that incident, my lord, I have not found anywhere in the
But
CD.
reason is
In
not
fact, the
mentioned.
statement of the witnesses also.
My lord, reason is not mentioned in the FIR, my lord. This is the fact, my lord. Otherwise, in normal condition, no dispute will arise, my lord. So he give slave, my lord. And that is a very shameful for him, my lord. And there is argument, my lord.
And why they
And
have
three-
entered, my lord,
my
regarding
lord,
that aspect,
my
my
lord,
lord, there is nothing in
326 is not present, my lord.
Question is that in a pre-planned manner, it is there,
Yes, yes.
and without any reason.
But yes, but in CD also, I have not found any reason for why.
Very
And maybe
unfortunate.
that may be a
Some
reason.
can say has to be
Yes,
some,
yes.
because a reasonable person will not enter
No.
without any reason. One word is there pre-planned and another second
Yes.
word is without any.
And the statement of witnesses also like that all these accused persons were entered unauthorizedly and thereafter assaulted all these persons.
Against my lord, hold the family member, my lord. Both are neighbor, my lord.
And what about your
And
37?
for
My lord,
What is 37? Oh, sorry, 27?
27 also, my lord, there are total, my lord, 7 accused persons. My lord, his item number 17 is the one Huzur Ali, and other accused persons is item number 27.
well, other is my lord for pre-arrest and one arrested, my lord. Kindly examine, my
Ali
lord,
was
the
arrested
nature of the
because-
injury, my lord.
If, my lord, his submission is correct, then, my lord, initially the incident occurred with Huzur Ali, and that Huzur Ali was already arrested. But in the CD regarding that incident, there is nothing in the CD.
All
And
the
therefore
section,
other accused persons already.
well, the section concerned is valuable only for 118 subsection 2. The grievous injury is not present here, my lord. And dangerous weapon also not here. So, my lord, bail may be granted, my lord. Other section is valuable. Maximum, my lord, here come, my lord, that 117 subsection 2, earlier 325. That is valuable.
Heard Mr. Anuddin, learned counsel for the petition. Also heard Mr. Learned petition and people. It's an application, the sections. Submitted by Mr. Uddin, counsel and counsel for the petitioner that the accused petitioners, the present accused petitioner is innocent. He has not committed any such offense as alleged evidence. However, it is a fact that in the day of incident, the informant coming in a bike hit the present petitioner, and when and in the front of the house of the in the front of the house of the petition when there was an altercation and scuffle took place between the two family groups, and in that process, the petitioner also slept on the informant as to for his misbehavior, and in that context, there was a scuffle between the parties. But no such incident had happened that is in the FI, and he further submitted that except some minor injuries during this scuffle, no such previous injury is caused to attract section 118 subsection of BNS, nor there is any outbreaking of honesty of the wife and daughter of the prisoner. The accused petitioner is in custody since 27 and 26, and thus the IO got sufficient opportunity to interrogate him, keeping him in custody, and hence his further custodial interrogation may not be necessary for the purpose of it. Next, Mr. Board submitted in this that there are sufficient implementing materials against the present petition, with whom initially the incident had happened, and to injury report is also available for victims. However, the injuries are found to be simple in nature, caused by lack of sight. Mr. Godford submitted that some kind of injuries are already sustained by the victim, and case is still under investigation. Hence, the bail petition may not be considered. Next, getting the submission made by considering the matrix available in the case that the nature of injuries sustained by the victim. This court is of opinion that further custodial interrogation may not be required according to this also. This is case from which place?
Well, it is CGM Golpara.
Very satisfaction of CGM. Now 27 to 9. Abstain, suspend. It is submitted by Mr. Putin that the present petitioners are the family members of one of the co-accused Fazar Ali, and on the day of incident, after the quarrel between the informant and the co-accused Fazar Ali, these petitioners, being the family members, came out of their house, and the family members of the informant also came to the place of occurrence where a quarrel and scuffle took place between the parties. That apart, there is no such incident had taken place as alleged in the However, all the petitioners are ready and willing to extend their cooperation in further investigation of this case if they are granted with the privilege of witness. Mr. Potter, the learned counsel again declare assumption negative. Their custodial interrogation may be necessary to provide. Okay, you are granted with interim pre-arrest bail. Disposed.
I'm blessed.
Yes, we have received here case that
Case I received my. Well, at the time of if I can next question. At the time of filing this petition, my lord, FIR was because only one report was called for, and later on I have received the CD. So regarding the contents of the FIR, my lord, that is, so FIR is not.
No, in this case, lordships, petitioner and informant are married each other, major and married lordships. Thereafter, board are, my lord,
you are filing the FIR in this manner, or you want to file it through additional?
no, my lord. Actually, my lord, earlier I have filed without an FIR lordships, probable case lordships.
No, that I'm not on that. Now you cannot file this way, na? You have
I
to
can,
file.
I can
one
file
to
additional,
addition.
I can file additional affidavit.
To an addition. Can file. Otherwise,
Well,
you
I
have received
CD received, my lord, statement of the victim is also available, my lord, from the contents of the CD and from her statement, my lord. Actually, victim or my lord, accused person is already a married person, but concealing the said fact, my lord, as per my lord Muslim personal law, my lord, in presence of one of his friend as Qazi, my lord, on a particular day, marriage was solemnized between the my lord victim and accused. And thereafter, later on, she came to know that my lord, the victim is already married. And in her my lord FIR, she also my lord stated that my lord, at the time of lodging the FIR, she was pregnant of 4 months, my lord. Regarding that aspect, while I try to find out any medical document, my lord, one note of the IO that it is to be noted that victim states that she has already conducted a medical examination on her own. Therefore, I asked her to produce her medical documents. She stated that she would produce the same at the earliest, but there is no medical document in that case. Then, okay. And regarding other allegations, my lord, that by concealing the said fact already, my lord, as per Muslim law, he married. And thereafter, when she asked the accused person that marry me legally by my lord, but later on he has only applied, but thereafter, my lord, no legal marriage took place between the accused and the victim. And regarding that aspect, that they were living as my lord, husband and wife. Some witnesses also in the flat wherein they were staying, my lord. Some of the neighbors of that apartment is also statement is there. They stated that since long they were staying as husband and wife there, and everyone knows that both are husband and wife.
Yes.
So under which case is registered now?
Case is registered under section, my lord.
Section 85, Lordship. There is cruelty, Lordship. Section
Under
85.
section
85.
3182, 82.2 and 85 of the BNS.
All are available, Lordships, except 85. There is cruelty, my lord. And my lord, the petitioner has an interim. He appeared, statement recorded, Lordships.
He appeared, statement recorded, my lord. He stated that yes, my lord, already before he married, already before 15 years, my lord, he stated that. And thereafter, my lord, concealing the said facts, he married the present victim, and thereafter also established physical relationship. And later on, my lord, মই তেওঁৰ ভাড়া ঘৰত তেওঁৰ লগত আছিলোঁ কিছুদিন। মই কোৰ্ট মেৰেজ এপ্লাই কৰিছিলোঁ, কিন্তু মই এতিয়ালৈ পাপি আহমেদক বিয়া পতা নাই। তেওঁ বৰ্তমান প্ৰেগনেণ্ট।
Biya pata nai means, but
Court marriage has done one.
but as per Muslim
Muslim
personal,
personal in presence of not in presence of the family members. Some of their friends, my lord, were there. No family members were present.
Kaji or where?
Before Kazi. Kazi is also one of the friend of the accused, my lord.
Nikah, my lord, nikah conducted,
So
but
that nikah is no value now.
Yes. And he also stated that, my lord, she is now pregnant. But regarding that aspect, no medical documents.
Yes, Sultana, yes. Yes.
During the pendency of this data, there is any negotiation is going on. In that, I do not know because he has not about the case. And I'm happy to work with the within my time because there's going to be sufficient. I what have given
No, regarding negotiation too, we do not know. Now, only issue raised by Mr. Borthakur is that he applied for his legal marriage, but till that the marriage is not legalized or whatever. One before Kaji marriage was there as per Muslim personal law, but
matrimonial
Lordship.
it seems to be. It
Yes.
seems to be, but not exactly cannot say matrimonial. There are some other issues.
Yes.
Any allegation is that this person is absconding.
No.
To perform legal marriage.
No, he is an
Now
interim.
you are ready or you are not ready?
No, he is an interim, Lord. He appeared not
No,
absconding.
not interim. You are ready to marry her now?
Yes, I am ready to marry her, Lordship. Because my lord, nikah already performed, Lordship. Nikah already performed. Only court marriage has not been done. That is the main allegation, Lordship.
Now, my lord, she don't want to marry, my lord. She stated that তেওঁ যদি মোক ৰাখিলে এতিয়া মোৰ লগত এতিয়া মই তেওঁৰ লগত নাথাকো কাৰণ তেওঁৰ অলৰেডি ৱাইফ আছে। She stated last portion, my lord. আগতে গম পোৱা হলে মই তেখেতৰ লগত কেতিয়াও বিয়া নহলো হয়
মানে she is also married lordship. She has a my lord child lordship. She is also married.
regarding that aspect my lord, there is nothing in the CD
She is
he also
my
accused
lord,
also in her in his statement stated that she is pregnant now and my lord she also my lord,
And my
stated that fact in her statement but regarding that no medical document is there in the CD till
my lord, concerning the marriage section 82 of the two lordships, that is available lordships. Kindly see my lord section 82 within bracket two lordship and 318. Kindly see lordship. Though 10 years imprisonment is there, trial by the magistrate, but it is available lordships. And section 318 within bracket 2, that is also available lordship. Only section 85 is a non-available. That is cruelty lordships. She is not, my lord, I have not done any cruelty lordship. She is not within me lordships. She is living separately. I am also living separately. My lord, there are some other forum.
Regarding the allegation of cruelty, no such evidence.
cruelty there is
No lordship. Only that, my lord.
My lord, abort is also done, that she has done abort.
But now she is pregnant, I think.
Now, now she is not carrying pregnancy, my lord.
Oh, she is not carrying pregnancy.
Pregnancy, she has done abortion in her
She has done on her own.
Medical record we don't have now. Mr.
in the objection.
objection she has filed but in the CD my
We have
lord,
already filed the medical documents.
My lord, termination that I am not on that, my lord. Because my lord, she on her own will lordship. She has done lordship. She is living separately. I am also living separately lordship. And my learned friend provided me the objection lordship today itself lordship. And without the medical report and without the annexures lordships. So my humble section 85
But
only.
you got your pregnancy terminated.
Yes.
But whether that information was given to the petitioner or accused?
You must, you know about the abortion.
How can I?
He compared to abortion because they could not
No, but is there any section or is there any, I mean, material that she was compelled to go for abortion or to do her abortion?
She did not inform me lordship.
Is there any or without any information you did by your own
that when they avoiding to beat her, she was compelled to abort.
No, that is her case. She was compelled or not. You
Yes.
cannot say it's compelled.
Lordships.
If she got married with the accused, may not be legal marriage, but the
Lordship.
marriage before Kaji was there only. You are not denying the nikah because till now you are the wife. And as per Muslim personal law, most probably the marriage got solemnized, may not be true legal marriage. But till now it is acceptable that second or third marriage is acceptable. It's not you are still will be considered as a wife
Lordship.
even though there is no legal marriage because that is still there.
but the only difficulty in that case is that only the friend of the accused persons was present on that day.
That may only two witnesses record lordship.
Otherwise, other my lord, whether they will now say that whether any such marriage was solemnized between them or not.
Only three witnesses
Let
record.
her submit all these medical documents before the IO. It will help in the investigation, my lord, because those are not part of
So
the
you are
CD.
going to return back the case diary at this stage or what?
Yes, my lord, I will return the CD, my lord. Otherwise, accused person also appear, his statement also recorded.
Yes, lordship.
Heard Mr. M. Hawk, Delaney for repetition. Also heard Mr. Keyboard Food, Planet Edition appearing on MSPR Sultana, the legal aid council appearing for the informant. Is submitted Mr. Hawk that after obtaining the order of interim bail, he already appeared before the IO. His statement is recorded and thus he is cooperating in the investigation. So Mr. Botker also submitted that the accused had already appeared, cooperated in investigation, but though the case, but he submitted that the case diary is received, but there is no medical documents so far collected by the IO till date, as the petitioner, as the informant was supposed to provide all the medical documents of her treatment and other treatment, etc. In view of this, Mr. Potter submitted that the CD may be returned back calling for an updated one along with all medical reports if any. If any. Considering this aspect of the case, let the CD be returned calling for an updated one. The PS1 it can be.
My lord, on my lord, March, April, on 4th of May. Then on my lord, 30th of April, 30. And your lordship, my lord, victim will be directed to submit all those medical documents before the IO, my lord. Otherwise,
Further, the victim informant is also hereby directed to submit all the medical documents before the IO, so that it can be collected during the course of it. It will be continued till next year.
Obliged.
no, I will sort of the
My lord, medical documents regarding the victim, my lord, what she has given, it may be original, my lord, in the court, my lord. If there is no record in her, then it will not be able to.
You see to it, but during the investigation, it is the duty of the IO to collect the medical documents, or it is duty of you also, because you have submitted it, you have done the medical examination, etc. by your own. So if it is that the position, you should submit.
or otherwise, your lordship, he has already accused person appeared, my lord. And my lord, all those may direct on the if your lordship can return back the original of the my lord, those medical documents to the
No, that cannot be.
oh that yes, ma'am.
If she has any copies and all, then
Otherwise, your lordship may dispose it.
Dispose of lordship.
Your lordship may dispose it of also, my lord. If he see agrees, my lord. Otherwise, only regarding submission of medical document, he has appeared. Otherwise, cooperating with the investigation.
Lordship.
I have already passed here.
Oh yes, yes.
Additional affidavit. Bye bye.
Please, your lordship.
Mhm.
Lordship, item 20 and 21 together, lordship.
20 and 21, both. Yes, what about 20 and 21?
20 and 21, my lord, case diary not received, ma'am.
Lordship, petitioners are on interim and they have appeared before the investigation officer. Interim order may continue.
2021, CD not received. Issue reminder. Interim be continued till next date of listing. Yes, what
On 27th of April, ma'am.
your interim is extended 27th of April.
Yes, lordship.
27.
It is not received, my lord. IO has paid for another debt, my lord.
Lordship, there is no interim, so
No interim, and the last occasion most probably PI was directed to procure the case diary, because it is stated to be lying in before additional session just come up petro.
My lord, that is there. That
So
is in
why
the
he
earlier, my lord.
could not collect it?
My lord.
Why he could not collect
This is
it?
the earlier, my lord. Just earlier, my lord.
Okay. Just get the instructions also. What is happening? Because it was stated that the line before the addition.
My lord, in the earlier occasion, it is.
Yes. Because it is not on interim also. So just at 2 p.m. may fix. Here we have received.
May I please, your lordship?
Copy. Yeah.
LCR also received, lordship.
My lord. কি additional affidavit file করবা?
LCR. Please, your lordship.
01. Nagaon case diary. One Nagaon PS case number 770 was also called for, or what?
No, Nagaon 770.
Nagaon 770 is PRC 101.
101.
I mean PRC 101 26 in connection with Nagaon PS 770.
Yes,
Is it?
lordship. Yes, lordship.
101. 101 is PRC 101 26 in connection with Nagaon PS 770. Is it? 101 is PRC 101 26 in connection with Nagaon PS 770. Is it? 101 is PRC 101 26 in connection with Nagaon PS 770. Is it? 101 is PRC 101 26 in connection with Nagaon PS 770. Is it? 101 is PRC 101 26 in connection with Nagaon PS 770. Is it? 101 is PRC 101 26 in connection with Nagaon PS 770. Is it? 101 is PRC 101 26 in connection with Nagaon PS 770. Is it? 101 is PRC 101 26 in connection with Nagaon PS 770. Is it? 101 is PRC 101 26 in connection with Nagaon PS 770. Is it? 101 is PRC 101 26 in connection with Nagaon PS 770. Is it? 101 is PRC 101 26 in connection with Nagaon PS 770. Is it? 101 is PRC 101 26 in connection with Nagaon PS What was the case, in fact?
Lordship, it is the allegation that the petitioner there have a petitioner and a petitioner sister and accused. Informant sister and accused has a love relationship for the 4 years. After that, petitioner married to another girl, and the informant sister, after knowing this incident, the informant sister commits suicide.
She committed suicide.
Yes, Lordship.
So case has already been charged.
Charged, Lordship.
You are showing it an abscond.
He was cooperating. And my cognizance taken on 9/2/2026 and someone issued. Next date is fixed on 20/5/26 for
Lordship, at the time of incident, petitioner was not in there. He is in Kerala, Lordship, for the work.
What about it? 9/2/2026, cognizance was taken.
minor.
Someone issued.
Someone issued.
Someone
And fixed on 20/2/5/26 for appearance.
Now we have received summon only.
Yes, Lordship.
My lord, here I have gone for the record, my lord.
Lordship,
Yes, sir.
Lordship.
Yes.
So broken relationship in lots of apex court judgment, broken relationship between the two persons have no abatement would to be committed suicide. Lordship, lots of apex court judgment have clearly stated that
The question is that at this stage we are not really going through the entire merit of the case.
Mine.
Let us see, you will giving a chance, otherwise.
My lord, one important thing is that my lord, in the suicide note, my lord. Here in the suicide note, although not in the my lord, record, my lord. Here it is said that due to the my lord, due to the Umar Farooq, my lord, present petitioner, he has consumed the poison, my lord. Betrayal, my lord. After she was love affairs with for last 4 years. My lord. He after just before 5 months, he has married another girl, my lord. That's why after that, she committed suicide, my lord, due to the betrayal, my lord, by the present petitioner, my lord. And Lordship may kindly produce, my lord, from the FIR itself, my lord. It was also mentioned in last 4 years, my lord, and marriage was done by the present 5 months back, my lord. And thereafter, due to the betrayal by the present petitioner, my lord, she has committed suicide. In the suicide note, it was said, but suicide note is not available in the record.
Lordship, there is no evidence to show that the petitioner has promised to marry to the informant disease girl.
From the statement, Lordship, kindly please statements are there.
I have seen one. Okay, let him appear. We give it an interim petition.
Lordship, protection.
Let him appear.
My lord, no interim entry statement.
Lordship, can interim may protect. Lordship, protect.
There is only open to him to appear before the court below.
Pardon?
As someone is issued, my lord, there is open to appear before the court below, my lord.
Obviously.
15 days time, but 10 days time may be allowed, but thereafter court below will consider.
Lordship, interim may be protection may be considered, Lordship.
But otherwise, his involvement is there, my lord.
Lordship, see the apex court judgment, Lordship, para 13, Lordship.
These will come at this time. It's trial and all.
Fine.
No, no.
Protection may be done.
Done. Bishop, done it. Then with scan copy of the submitted it is the fact both the petitioner and the deceased victim had love relationship and love relationship and that apart. But he never promised to marry as stated in the act. But at the relevant time incident, he was at Kerala and came to know after we pregnancy, came to know about the same only coming back from Kerala. But the present petitioner is ready and willing to appear before the learned trial court below and to investigate accordingly if some interim protection is provided. Next one. Mr. Sharma, the learned petitioner PP submitted that the charge has been lost considering sufficient incriminating materials against the present accused petition. And there was a suicide note also where she had wrote as to why she was found to compelled to commit suicide. But they said the note is not available. Suicide is not available. Scan copy of the case diary or case diary. However, he submitted that the only summons were issued to the petition, and hence he is at liberty to appear before the learned trial court will be honored before the next instance. During this submission made by considering case, the present petitioner is hereby to appear before the learned session judge with an application for bail, which may be considered in accordance with, however, till 15 days from the date of order. And as an interim, no prohibitive action shall be taken against present petition. Accordingly, you are for 15 days, you are protected. Yes,
God bless.
this one. What is 28?
Well, in 28, she did not receive money.
May I please your ladyship? Let's say this is the application I have filed for two petitioner. So thereafter 19th of March, petition number 2 got arrested, my lordship. So may I just humbly pray for the petition number what they have, my ladyship. So FR in page number 17, my lady. Two arrest. So I'm just praying for the petition number 1, my lady. May I pray
Who got arrested? Number 2.
number 2, my lady. Let's see, may I just read the FR first?
No, it's okay. We have not received the case diary.
Not received that.
Ladyship, this case might not need the case diary, my ladyship. Case diary, lordship can call for, but this is a fit case, so lordship can give me the interim protection, my lady. So may I just make my submission? Because co-accused got the bail, my ladyship.
No, we're calling for a case diary. Right. But Mr. Amin did not be sure. This she did not receive. This submitted by Mr. Amin that during the pendency of this case, the petitioner number 2 got arrested in 19/3/2026, and hence he doesn't want to raise the petition for the response petitioner. Issue reminder, call for the case diary. Yes, when it can be, it is not on interim.
Can I pray for short date, my ladyship? He is in apprehending arrest, my lady. Otherwise, this application will be infractious.
7th of April. 7.
It will be short, very long, my lady. Can I pray?
Okay.
7.
What
Humbly, can I pray before 7th?
Fine.
Because he is apprehending arrest. Otherwise, this application will be infractious, my lady.
From where?
Gwalpar.
From Gwalpara, my lady. Otherwise, this application will be infractious, my ladyship. Other co-accused got the bail, my lady.
That is different. Rules are different.
I can.
He is involved. It is not possible.
Lady,
to
then
say
can,
at this stage, my lord.
if that is the case, then I have to make submission myself.
We cannot say.
Doctrine of parity, I can establish, my lady.
In fact, it was
My lord, in the earlier
there
occasion,
was a request made by Andia.
my lord,
Yes, my lord. I was
it
out of station, my
not
lord.
called for.
Not called for, in fact, yes.
My
Because it was a request made, so it was listed.
listed man.
Now he is pressing.
My 7 4 man.
CD not received. CD issue, CD not received, no, CD collect for.
Mine.
Call for request.
Call for.
7.
I think
Deeply organized, my lord.
May I please. So this is application for passing, my lord.
Yes,
Passing of,
state is there, Andy. You are there. We have received this scan copy.
well, it is on a private complaint, my lord. For,
Pardon?
this application is for passing of a private complaint.
Yes, washing it. I can understand. No, I'm asking scan copy. We have received that.
Oh, yes, no. Scan copy is as per the public is there. Notice, sir, whole.
Notice is sir.
Yes, my lord.
Where from you are saying notice is sir?
Office note, I think it is.
Office note is there.
Basically, my lord, it is a multiplicity of procedure. Admittedly, my lord, the complaint company is my lord, from Noida.
They were asked to find out the track consignment report, and from where it is reported that it was delivered to the address on 12/3/2010.
Yes.
So it seems that the service is already come.
Otherwise, basically, my lord, on the basis of that complaint,
Basically, my lord, it is on the point of jurisdiction. Whether, my lord, admittedly, my lord, the complainant is having its register office at Noida, my lord. It is having its factory in Mathura, my lord. Now, my lord, the accused is having its factory in Dholpur, Rajasthan, my lord. Whether an offense, even assuming any offense is committed, it is committed in my lord, Dholpur, Rajasthan, my lord. Whether on the basis of offense committed in Rajasthan, my lord, and a complaint, criminal proceeding can be initiated at Boko, my lord. That is the basic question, my lord. And in complaint petition, he has admitted, my lord. They have
So
admitted, my
you
lord.
have come only on the jurisdictional part.
Yes, my lord. And my lord,
let the trial court first decide the
my lord, trial court cannot, my lord, trial court, my lord, cannot revise its own order.
trial court can first decide the point of regarding.
No,
Because if you are
my lord,
only purely on the jurisdictional point, then trial court can decide.
no, my lord, I'm sorry, my lord, whether once the cognizance is taken, my lord, the trial court is, I think, he cannot change its own order, my lord. Unless the charge is at the only at the stage of framing of charge, the trial court can, my lord. Otherwise, not, my lord. And if
It's the authority. Why you are saying that they can?
no, my lord, trial,
Because in this case, initially police has submitted final.
yes, no,
And
my
thereafter,
lord, my lord,
final report on the basis of the objection filed by the my lord, complaint. Thereafter, my lord, again this complaint petition.
my lord, just have a look at, my lord, the facts of the case. First, he lodged an FIR in the 2016 at Noida, my lord. Again, the same company of this accused number 1, my lord. Then that proceeding was stayed by Honorable Allahabad High Court, my lord. Then again, 2021, he lodged an FIR in the Noida, my lord. Honorable Allahabad High Court, my lord, by order dated, my lord, that order is at page 57. Order dated 79/21, my lord. That proceeding was stayed. Then, my lord, in September, he lodged an FIR. My lord,
At best, we may pass a direction only.
Yes.
Washing may not be.
Let the petitioner
If it
first
is
file
only
an
on the
application
jurisdiction
before the trial court regarding
No,
the
my lord, trial-
decide the point of jurisdiction parts, my lord. And thereafter, my lord, trial court will decide.
there is a judgment of Honorable Supreme Court also, my lord.
On what point? Just tell
Only
us.
on the point of jurisdiction. If the offense is admittedly not within the jurisdiction of the trial court,
Was there any earlier rejection order on which they have approached the Supreme Court or High Court? But this is the case where they directly have approached the High Court without filing any application. This is a case of Supreme Court. What it is not the case of meaning of yes. Jurisdictional point can be taken up.
my lord,
But now the question is, you have not approached the learned trial court below.
No, during investigation, my lord, we participated in the investigation. My lord, first the complainant lodged an FIR before the SP Kamrup, my lord. Then the SP Kamrup directed the OC Boko police station to investigate the matter, my lord. Then the Boko police, my lord, examined the complainant side and also issued notice to the, my lord, the accused person, my lord. The accused participated in the my lord, the investigation and submitted their document. Their allegation is that from the year 2019, my lord, these accused persons are manufacturing this, my lord, surgical gloves, etc., my lord. Now, my lord, he has submitted the documents which shows, my lord, that his factory was established in the year 2015, my lord. So on that basis, my lord, the OC, the IU has submitted final report, my lord. Finally, FIR was lodged in there 2021, my lord, September 21. Final report was passed.
Direction was given. That with a direction to the respond number 2 to return back the case to file it within the jurisdiction. If the only the jurisdiction issues it.
And secondly, my lord, lordship may have a look at, my lord, page 30, page 51, my lord. He lodged similar
This
FIR on
issue is
20.
never raised before the learned trial court.
Yes. No, trial court we have not appeared, my lord. Because
We have not appeared at all.
no, my lord. When we came to know about the issuance of summon, we approached this honorable court, my lord, for questioning. Because, my lord, the same company has lodged an FIR on 21/7/2016, my lord. If FIR was lodged on 2016 before Noida police station, my lord, then on the same allegation, how a second FIR can be lodged before Boko police station, or how a complaint case proceeding can be initiated before the Boko judicial magistrate, my lord. That is the only question, my lord.
Who stays in Boko?
Huh?
Who stays in Boko?
Boko, nobody stays, my lord. The allegation is, my lord, just may I read the complaint? My lord, their allegation is that they have one of their branch at Boko, my lord. That is in the complaint petition, my lord. If no case is made out on the basis of complaint petition, then it can be paused, my lord. There is no.
You are come only on the jurisdictional point, or
No, I am
the merits on the merits.
Oh, my lord, I am on jurisdiction point, my lord. First, my jurisdiction point. Then, my lord, it is the allegation is that it is the complainant company has some patent.
No, you are on merit also.
Merit
You
also.
cannot take two plays. You are in the purely on the jurisdictional point, or what?
No, I am on both, my lord, because I have 3 points, my lord. My lord, just see, my lord. Jurisdiction, there is no jurisdiction, my lord. Then there is, my lord, multiple proceeding on the same issue, my lord. The basic issue is that, my lord, I have.
I mean, submit on merit only then.
My lord.
Submit on merit only.
Jurisdiction also, my lord, only on the
Otherwise,
basis.
if he wants, because complainant, my lord, basically, my lord, if complainants need to be present, either he has submitted that already, complainant has received. The complaint not yet appeared, my lord. Regarding that aspect, my lord, I will have to go through in detail, my lord, from the scan copy. Otherwise, from the, my lord, if he wants to raise this jurisdictional point, first, if the other party also appeared before the trial court, my lord, because on the basis of the, my lord, complaint petition, objection petition, my lord, protest petition filed by the, my lord, respondent, the case proceeds. And now in this case, if, my lord, why they have not received notice, my lord, for, my lord, I will have to check the record, my lord.
My lord, my friend has nothing to. It is the my lord. My lord, the accused may intentionally not, because, my lord, he is aware of. He is aware of the fact, my lord. The FIR lodged by him before the Noida police.
No,
that
I
has been
cannot say
stated, my
that
lord.
state is a formal party, because thereafter, because FIR also lost, my lord. So records, my lord. Otherwise, it would have been appropriate for him to first raise the question of jurisdiction before the trial.
How, my lord? Unless, my lord, if no case is made out, why I should go to Boko and, my lord, obtain a bail, and then I have to wait for, my lord, the consideration of charge.
He is on merit also.
Then I will have to go through the scan copy in detail.
My lord, my lord, I have it is a complaint case. I have the copy of complaint petition. I have the statement of the, my lord, the witnesses. What more is there in there? I will make the impugn order also. What more is there in the scan copy? And this copy has been furnished to my learned friend when this criminal petition was filed, my lord.
Because, my lord, why police has submitted?
Why it is no, when there is no, my lord, Boko court has no jurisdiction at all, my lord. if offense is assuming, my lord, that there was any offense, it has been committed in the
One
state
part of contract was in Boko.
my lord.
One part of contract was
No, my lord. My lord, may I just read the FIR. My lord, their allegation is that the complainant company has one of their branch at Boko, my lord. Accused and nothing at Boko, my lord. So, my lord, only on the basis that, and my lord, this is also contradictory. My lord, if they have their office at Boko, then my lord, why the person who has filed this complaint, he comes from Noida, my lord? Just see the address of the complainant, my lord. May I just read, my lord? Anandita Healthcare Officers at
we'll
Noida.
hear the matter only. Yes, what a brief you did it, and we'll hear the matter. Otherwise, we cannot spend time. You go through because the
Well, let it-
petition,
let-
when
my
I
lord, it
passed
can be
the
taken
order
at-
of
my lord, my
interim
friend-
period as interim bail, in that case, I heard Mr. Gore and submitted the reflected in the order sheet as to why the interim was granted. Because obviously the manufacturing, the office was at Rajasthan, and there are
It is basically my lord,
and all.
business rivalry,
So,
nothing else.
Sometimes later on, this from Boko case is registered. Now we have come to know that the complainant has some connection in Boko. The office in Boko is also there. So that regard, you can you can see the case record, and that part is also submitting on merit of the case. So if post and merit may also be considered. So if you want time, then
My lord, let my friend go through the record. It can be taken up after 2, my lord. After 2.
if possible
My-
only, because there are
My lord, it hardly, I will take only 10 minutes, my lord.
No, you
I
will
just
take
say
10
on the basis of complaint petition itself. No, it is a private complaint. Why, my lord, why my friend is so worried about it? It is a private complaint. No, yes, you have to assist the court. No, I am not also not. So but you have to be fair to the complainant as well as the accused also. You cannot be take the stand of the complainant when it is a private complaint. And the prima facie it shows that there is no case is made out. Or it can be taken up tomorrow, my lord, if my friend wants some more time.
Yes, Bothakur, will you be able to at 2 p.m. One matter is already fixed at 2. There are other matters also, I don't know.
After, my lord, after that,
At 2 today?
At 3 p.m. My lord, after that, bail matter lordship may take up, my lord. After that, bail matter.
After that, no, there are many matters.
Oh.
It is not a case that only one matter is fixed at 2. There are many matters.
No, interim is already there, but my lord, on the basis of complaint petition, no case is made out, then what it has to be called.
That is his submission, no case is made out.
No, you
My
go-
complainant is
let me-
not there. I will
let
have
us-
to place
my
the
lord,
case
let
of the
us-
complainant also.
let us go through the case
So,
record,
while
the
my
complaint petition.
if complaint would have been appeared, then definitely my lord, I would have sitting here and my lord, they are.
Because one FR was there, thereafter, after Naraji, only the case is raised.
Yes,
na?
yes, my lord.
So then,
Then, my lord, no, not only that, my lord.
That I cannot say, but after going through the all
No,
the
but
things,
my lord, then my
there
lord, we
are
can.
some prima facie case. That's why
No, my lord,
after
yes,
Naraji
yes,
petition, the
yes,
case
my
has
lord.
been
Then, my lord, then we have to consider, my lord, the statement made.
No, we are not on that. I'm saying that initially FR was submitted,
Yes,
and thereafter,
yes, ma'am.
On Naraji,
Yes.
the minister had
The-
concerned
yes,
to
my lord,
consider
then,
these things, and then the cognizance was taken.
My-
So
my
there
lord,
may
my-
be something, I don't know at this stage.
My lord, but
So
my lord,
we have to stop the common or is I think either 30 or first. Can it be?
Yes.
It will be okay. Either 30th of this
30th,
month or first of
38, my lord, 38.
30.
30.
If my lord, the respondent himself, my lord, he submitted that
My lord,
protest
my
petition
lord,
to
he
the
is
trial court,
intentionally.
and they have not received notice, my lord, here in this My lord, Gauhati, my lord, why they have received not yet received notice?
My lord, actually, my lord,
We were asked to get the track consignment report.
They can even tell the my lord respondent to yes, one petition has been filed against them.
they know about it, my lord. They know, my lord, two FIRs are there
Now
in.
see, they are interested with the case record. Otherwise, after getting the Naraji, they
Hello.
wouldn't have appeared in case, produce the case. So
No.
they have already appeared getting the
No, but-
notices from the court, filed the Naraji petition, and tried to get the order of cognizance was taken. So
No, but-
definitely they are interested, but it's not
but
the
my
case that
lord, in
after receiving
CRPC,
notice, they
my
are
lord-
not appearing. It's
my
not the
lord,
case. They are interested party.
my lord, in CRPC, I think there are no provision that the trial court can change its own order.
No, I'm not on that. I'm saying about
No.
the respondent.
Yes,
They are
yes,
interested.
yes,
They are
yes, yes, my lord. But my lord, he is also not appearing there in Boko also.
Why? How he is not appearing?
Because my lord, in Boko courts, my lord, dates are being fixed, and my friend goes there, my lord. Nobody is appearing there. My lord, it is only a case, my lord, just to harass the, my lord, two FIRs before the Noida police, my lord. One money suit is also in the Rajasthan, my lord.
Made by Mr. Gauhati, the state respondent is fixed on 03 and 03 in 26. Okay, well, listing it on 38. Let us see.
Obligement.
Wait, please, Your Lordship. Your Lordship, kindly pass over the matter for the day. My senior's family member has passed away this morning, Your Lordship. She is not present at court today. So kindly this matter may be taken on some other date.
My lord, here also, full record is formal. Yes, was not received, man.
This
Not
year,
received.
Not received.
received, Your
Not shown in the post.
You are MS?
S.C. Murtaja on behalf of Miss R. Chaudhary.
MS S.A. Murtaza appearing on behalf of MS R. Chaudhary, Granite petition. So hard Mr. P. Sharma, the Granite edition PP appearing on the body of seen that the scan copy of PTCI is not yet received. Issue reminder raised you will be further. MS Murtaza also paid for an issue stating that the MS Chaudhary is in least after 1 week will
After Bihu, my lord, interim is there.
interim is there.
My lord, no proceeding.
After view vacation will get the matter accordingly after view vacation. Interim vacation will next.
May I please, Your Lordship? Lordship, we have an appeal against conviction, and the appellant has been convicted under Section 304, Part 2 of the IPC, and he has been sentenced to 10 years imprisonment and to pay a fine of rupees 10,000. Your Lordship, the appellant is behind the bar since 4/2/2018.
4/2/2018. Conviction.
Conviction is of Lordship.
10 years.
Yes, 6/2/2019. From the date of the FIR, he is behind the bar, and the judgment is of 2/2/19, and sentence was imposed on 6/2/19. Almost 7 years he is behind the bar from the date of the judgment. IA is also there.
My lord, here is the my lord criminal appeal bail, my lord.
Appeal will appeal today.
Lordship.
Is there any one
IA
arrest
is
or
there,
fine
my
is also there?
IA is for the bail.
It is the jail appeal, my lord. We have no any record at present also, my lord.
Otherwise, the copy of the judgment itself, it reflects that the judgment is of 2019.
No, it's okay. That is undoubtedly admitted.
Okay.
You are as a legal aid.
Yes, I am appearing as a legal aid counsel. And Lordship, inadvertently, Lordship, the informant was made a party in the case.
Yes, that's why I'm saying you have made the party. The informant is not. It's not so necessary.
It's not necessary. And in the delay application, Lordship, this honorable court was pleased to waive the appearance. His name was strike off in the delay.
And also had Mr. Sharma, the PP appearing And this is an appeal under section 74 CRPC against the judgment order dated 2/02/2019. Judgment and sentence dated 6/02/2019 passed by learned petitioner session Judge Jorha in sessions case number 74 of the 2000, convicting the accused appellant under section 304 part 2 of IPC and sentenced to undergo RI for 10 years and to pay a fine of rupees 10,000 with depositation. And it is appealed all for the TCR. Next, considering the submission made by Mr. Chaudhary and the name of the respondent number 2, begin from is hereby strike at the is be deleted from the cost title of the memo appeal at the risk of the appellant. List the matter immediately on receipt of the LCR.
And regarding the IA, Lordship, the IA, some order it with that. There is a IA for
Order means they have to, at least for their submission, there is nothing today.
Lordship.
That is the issue. Otherwise, I can understand he is
Lordship,
7 years behind the bar.
Lordship.
It's a long period.
And conviction is 10 years for, we will have to file our objection also.
The objection also, and without anything before that's Sharma is in a position also.
So I will be listed along with the appeal on the next date.
Immediately on receipt of the LCR.
Lordship.
280%. And application of section 389 CRPC for suspension of execution of sentence and to stay the execution of sentence and granting the accused and to allow the accused petition accused appellant to go on issue notice COVID. List the matter along with the connected criminal TL appeal number 1 of the 2020 immediately on receipt of the registry will do the need case records.
Mobilization. Lordship, in item number 11, it is also a jail appeal, Lordship. It has come up for admission. Delay has been condoned on earlier occasion. Lordship, he has been convicted under section 341, 376, and he has been sentenced to imprisonment for 10 years in respect of 376, and in respect of 341, he has been imprisonment for SI for 1 month. So appeal may be admitted. There is no private party in this case.
Okay, I the implement judgment and order is date of 28 February. Here also you are appearing as a legally?
Yes, yes.
Legally. Appeal be admitted. All for the registry will do the registry matter immediately. Since when he is in custody for?
Lordship, it is
2005 matters.
Lordship, from the date of judgment. Otherwise, regarding the other part, I have no knowledge whether he was
28/3 date of judgment.
from the date of judgment.
28/3/2025.
Yes.
About 1.
But regarding whether he was remaining in jail during the investigation state, that knowledge is not within me. But regarding that part, yes, that I have to check in the LCR.
Or at best you can get the instructions from the jail authority. Otherwise, there is no
Yes. That I can obtain.
same order.
Lordship, regarding the I also same order.
Same order will be there.
Lordship.
And we are listing immediately on receipt of
Lordship.
And we will file our objection after receipt of chairman, TCR. We will have to file our objection.
They will file their immediately. This year.
Well, in the earlier item number 10 also, we will file our objection.
Yes, file. We have incorporated those.
Obligation. What did he? 10 number 2 to? 11 to আছে তো?
Yes.
Please, Your Lordship. This criminal appeal is against order dated 12/11/2025 as per Ladet's sessions as Kapanlong Depot in Sessions case number T277 of 2012, arising out of ZR case number 249 of 1999, Your Lordship, where the petitioner was convicted to undergo simple imprisonment for 5 years along with a fine of rupees 10,000.
Under which section?
Under 307.
30.
Lordship, there was an alia also. Lordship, the petitioner has been behind the bar since the date of judgment.
Date of judgment was of 2025.
Yes, 12/11/25.
Delay আছে নেকি?
Delay নাই.
16 years delay এটা আছে।
Delay যখন নালাগে বুলি ক'লে সেইটো।
Is there any calculation regarding the delay?
Minor. Minor, yes. They filed one petition IA minor, but it is not numbered.
Ready. Right.
Mr. Sharma is calculated no delay.
Minor. But they filed one.
It was served
Served to us.
already, Your Lordship. Later the registry.
Most probably
But
registry
it
asked
was
that
minor calculated and
calculate. You are MS Hayat?
Yes, sir.
Not MS Jet. Sorry. Yeah, against the judgment and order to declare in SC T277 2012 arising out of PR case number 249 1999 in connection with Okajan GRPS case number 06 1998 whereby the appellant is convicted under section 327 IPC, directing him to undergo SI 5 years along with an extent it is at this year distributed in it test the matter immediately. Mr. Sharma, it is of 5 years, but you want to submit anything because there is nothing for us now.
minor. Minor, after Lachmi considered the intemperable after receipt of LCR, trial for record. This is the 5 years conviction minor. We will have
The
to
receipt of details.
minor.
But then it says a bit file under section BNS suspension. Judgment dated 12/11. File annexation just carrying the book in connection with case. Let the matter be listed immediately on receipt of the case and this year. This both the matters will be listed immediately after the TCR because to submit anything also verbally also there is nothing before record. So immediately after TCR it will be listed. Or you can approach the list.
Quickly obliged.
Okay.
Made, please, your lord.
Lord 20B, my lord. Contraband is 2.200 kg. Intermediary quantity, my lord. He is, my lord, imprisoned for 7 years and 50,000 fine. He is in jail, my lord, since 26/12/2023. And earlier also he was in jail, my lord. Now, my lord, he was the rickshaw puller, auto rickshaw driver, my lord, and the passengers were carrying some contrabands, my lord, the ganja, and allegedly, my lord, to be supplied to one lady,
Okay, we'll admit your appeal,
my lordship.
but let the TCR be received, then only it can be considered.
Yes, lord. Only,
Since
my lord,
when you are in custody?
my lord, since 26/11/2023. Earlier he was there, my lord, 7/9/2019 to 26/11/2019. Then, my lord, 26/12/2023 till date, my lord.
Then as a whole,
As a whole, my lord,
about more than 2 years, or about 2 years,
3 years, my lord.
about 3 years.
My lordship.
Okay, Mr. Sharma, anything?
Final. At this stage, let me admit call for the trial for record and interim may be considered after receipt trial for record.
At
My
least
lord,
there has to be something to.
My lord, we have
my
not recorded.
Today,
and another appeal, my lord, the why I submitted, my lord, the lady, my lord, for whom the contrabands were being carried by the passengers, my lord. I am the rickshaw driver, my lord, auto rickshaw driver, and some passengers were carrying, my lord. She has also preferred an appeal, and she has already been granted bail, my lord, and TCR is already available in the before dishonored court.
Oh, very nice. Can you tell us the number?
Criminal appeal number, my lord, 42/2025.
No, 42
It bail order. Good morning, bail. He has already been enlarged on bail, my lord. Ito ay bail ko.
PNSS. I read with section 438 of 438. It's about CRPC. Read with section 397 of 6. Against the imperial judgment that credited 5/12/2020 as 5. Special case and DPS case number 11 of the convicted accused appellant under section 20
Oh.
and 29 of the marks. Sentencing him to undergo RI for 7 years and to pay a fine of 50,000. Which release admitted for police. Raised with routine estimate TCR along with criminal appeal number 42/. I same source. The interim prayer for bail may be considered on immediate this raised both the matters along with criminal appeal number 42/. If TCR is already there, then we'll if the TCR will pass the order.
Before vacation, my lord, may I pay for a date if possible?
Date so immediately after vacation we are listing. Can you tell us the date, if any date is fixed on 42?
My lord,
Criminal appeal 42 is there any date?
42 because, my lord, in the main case, my lord, that has been kept as a part heard.
Part heard?
Yes, my lord. That is.
Then it is not possible.
Okay. 8-1.
8/1. And my petition will be for consideration of IA, my lord.
No, no. This in criminal appeal 42 you are not appealing.
No, my lord, not. That is some.
But it is in part heard.
Part heard.
I was granted, man. I in part main case was for part heard. It was kept as a part. Then
Part
it will,
heard to how it will be tagged with now part heard.
man, it will go to the present.
That code only. Yes, that's what I'm saying.
And
Can you tell us the any date is fixed for part hearing?
Not given, my lord, because we are following online only. And online it is
If
showing.
you can give us the date.
My lord.
Suppose, most probably there may be any date,
Date not-
as if it is in part heard.
Date not given.
List after 4. Then if in.
Then to
10, list after
Eh,
fraction, then
Then it will come after
probability is there. Come.
Because the stage of the criminal appeal, my lord, 42 and my case will be different, my lord. Finally, for the final adjudication, it has to go together, my lord. Not part.
read definitely.
What that is?
Appeal to definitely.
Appeal to.
As it's not
Appeal to sir.
42.
42 of late 2025.
Though most probably, though it is hard,
It's
some length,
2026
it may not be
You know,
kept as a part heard, because
25
part heard is
pattern.
sometimes create very
25.
problem for us. That's why most probably it is not
42 of
kept
late
as a part heard.
2025.
Oh, 26.
The probability is there that though it was hard at a length by some other court,
My lord.
but due to some difficulty on the
Better,
part
my
of
lord,
keeping it a part heard, that's why.
Better, my lord, we should confirm, because without confirming, I should not submit. My lord. Yes, I do know that. Right. 10 to
Last 10 to 20.
দুটা অৰ্ডাৰ থাকিব, এটা এপিল, এটা আইটো আছে মোৰ তাত, এপিল পেপাৰ চাইডত আছে মোৰ তাত। my lord, I have the certified copy.
Anyhow,
Any
if we list it along with
It
42,
was-
Then it will
PCR,
take
PCR will be there, then it will be
এটা আছে 81 অর্ডার আছে পার্ট হার্ড বিলি আছে
81.
81.
আৰু ক'বলৈ
Anyway, Mr. Sharma, if the TCR is already available with that record, a tagging of this appeal with criminal appeal will be because otherwise we have to wait for TCR for a long time. So if it is tagged with this one, then it will come
It
out.
will automatically come to the.
It will automatic. The court may hear the matter together, either by this court or by the other bench, what is there.
We have no
It may
say
come
with
together.
regard to that as a petitioner, my lord. We have no say with regard to that as a petitioner, but our only fair
You
would
can
be, my
say,
lord.
we are just simply listing it along with
Along with
40.
mine.
My lord.
That much only.
My lord, only I'm bringing a date, my lord. That is what, my lord. So far as
Fix now date.
Ah.
Because
yes, sir,
date
that
is
is
not
also
there.
correct. We'll proceed. We'll pursue the matter with the registry.
Pursue the matter with the registry, and if the 42 is in a very shorter date, there may be.
My lord.
So in that case, it will both be tagged together, and then the TCR we will have the opportunity to go through the TCR, and if Mr. Sharma also, if anything is to submit.
My lord. My lord. Deeply okay.
My lord, in this case, my lord, earlier we are directed to take steps in the new address of the respondent number 2, my lord. And I have taken up step on 27 to 2026, but the office note does not reflect any note, my lord, after 27 to 2026, my lord.
When you have taken steps on
27 to 2026 in respect of the
7 to 2026.
yes, my lord, regarding the present address of the respondent number 2, my lord. I have collected, my lord, and thereafter I take steps, my lord.
Not any reflection. No?
No reflection. There is no office note, my lord. So may I pray, my lord, a date may be fixed with an office note, my lord, regarding the steps taken on 27 to, my lord.
So, but you are sure that you have taken steps on 20.
My lord, it is shown in the, my lord, online, my lord.
Okay.
On 27 to, it is shown, my lord.
Mr. M.A.I. Hussain, Delaney Counsel for the petition of the appellant. Mr. P. Sharma, Delaney petition PP, everyone. It is submitted by Mr. Hussain that in pursuant to order dated 17/12/2025, have already taken steps to the respondent number 2 in his new and present address on 27/02/2026. But there is no office note to that regard to that. In view of this, the concerned section is hereby directed to verify as to whether any steps has been taken by the appellant on 27/2/2026 and to report the court accordingly regarding the service of business. We have received TCR.
Well,
TCR
TCR
has been received. Is the matter, you want any fixed date here?
so there is an, if possible, my lord, before vacation, if possible, my lord, only for the office, not my lord.
No, if service is not complete, POCSO is there.
No,
If
no,
the
yeah.
service not complete, then
Perhaps-
again it will go to.
Perhaps it may be completed because long back we have taken up on the present address.
Probability maybe there, may not be there, I cannot say.
So that may be fixed, my lord.
Immediately after vacation, that is on 21 will.
Fine. 21.
Your
CD
lordship, I would
received.
like to,
Okay.
From earlier, bail petition was rejected by the trial court on 26/2/2026. On that day, my lord, CD was updated up to, my lord, 7/1/26. Thane trial court has granted, my lord, one of the wife of the present petitioner that there was no investigation regarding the some of the only established only some documents, and that order dated 7/1/20, my lord, 26/2/26. Investigation, my lord, last update on 71/26. Till now, my lord, there is no till now in the case I have not till now I have not found anything against the person. Your lordship may kindly.
So here now, the husband is the petitioner here.
He is the principal of that. Your lordship may kindly peruse page 28, my lord.
Page 20 of the
Page
petition.
petition of the earlier rejection order of the trial. Okay.
Yes.
From the case diary, it appears that the IO have seized one Xerox copy of the mark sheet of this.
Where are you reading? Page 20 or?
Page 28. 28.
28. Oh.
28.
Yes.
From the case diary, it appears that the IO have seized one Xerox copy of the mark sheet of the son of the complainant, one money receipt, one monthly fees paid slip, and one depositor slip, which appeared to have been paid to credit of dispute interest academy for sum of rupees 8,400 on a month. It appears that the said documents were seized on 7/1/26. You will see 7/1/26 from the complainant. Case diary also reveals that only the statement of the complainant has been recorded by the IO, and there is no progress in the investigation. Thereafter, IO has not also to record the statement of the given witnesses from the investigation is on at the same statement. It is only up to 7/1/26. Only statement of the complainant, and regarding other those either here. Let him appear before the IO for recording.
You are Sushil Kumar Sinha.
Sushil Kumar Sinha. Because main allegation is not against the in the complaint petition he has made, the petitioner has made some government has made some allegation against the principal. He is the principal of the school. Against one my lord.
Binoy Mishra.
Binoy Mishra.
You are the principal or the Binay Mishra is the principal?
Lordship?
You are the principal or Binay Mishra is the principal?
No. Binoy Mishra is
Your
the
lordship may kindly peruse complaint petition.
ex-teacher.
Page, your first page 15, page 15. First page of the complaint. Accused number 1, Sri Binoy Mishra, and the principal, there is no name, my lord, specifically no one's name mentioned, but only the principal disciplinary.
Principal of Dispur English Academy. So you are the principal.
I'm the principal.
So though name is not there, but he is still.
And I'm ready to cooperate the police.
Every time after after passing it is we went to
So what is it from the complaint for the purpose of admission and out of the said amount? Accused number 2, rupees 20,000 and issued 3 receipts. Is there any receipt also issued by the respondent accused number 2, that is the present petitioner?
Those received
In para 17, just initial the first 3 lines. There are 20 accused person demanded rupees 50,000 from the complainant for the purpose of admission, and after the said amount, the accused number 2 took rupees 20,000 and issued 3 receipts of rupees 10,000. That I don't know why he had issued receipt also.
at that point of time the student,
Because if you go by the receipt amount, then it comes nearly about more than 19,600. If the I mean money receipts were issued. Let him appear then. Okay.
main allegation that my paragraph 4 and 5 of the complaint, case 17, real number 4, paragraph 4 and 5. That my lord, after passing SSLC examination, they provided a mark sheet. Then while he went to admission for my lord, for higher secondary classes, then he came to know that mark sheet is fake.
The thing is that nowhere they have said that they had sit in the examination. Nothing is the admit card was issued. Nothing has been mentioned, Your Honor. So
No, you have already issued the fake certificates as per the allegation.
that is why one another person was there, Vinod Misra. Vinod was an ex-teacher. Because I have that is why I mean my bail application at para 6, I have specifically said the petitioner had never issued any mark sheet or birth certificate to the SSLC examination to the Sonoba informant as alleged. If Vinod Misra had issued something, then I am not responsible for that.
But against you also, the specific allegation has been brought. The accused number 2 means you. Name may not be known to them because one Vinay Mishra is already.
Yes, accused person means both come into that definition. If
but there are specific allegations.
and in the police has seized only one money receipt. In bail order is clearly mentioned one money receipt.
No, police did nothing. That
Police
too
did nothing.
reveals.
That is why Lordship, I am.
Let him record the statement and I will let whether after the
While Mr. G. Gauhati, the learned counsel, the learned additional PP appearing on behalf of this is an application to section so and so CD receipt. It is submitted by Mr. Gauhati, the learned counsel for the petitioner. The representative petitioner is innocent. He has not committed any such offense as alleged there. There's no mention in the complaint that he had issued any money receipt. If any money receipt, etc., are being issued, that may be issued by the ex-principal as, but after taking charge as a principal, he never issued such kind of receipt to anyone. However, he submitted that the petitioner is still ready and willing to extend his cooperation in the further investigation of this case if he is provided with some information. Next, Mr. Gauhati, learned additional PP submitted to this regard that at the time of passing the earlier rejection bail order by the learned
Additional session judge number 1.
Judge number 1, dated 25/02/2026, is seen that the IO did nothing after 7/1/2026, 7/1/2026. No, no witnesses. Statement of no witnesses have been recorded by the IO, and no relevant papers were also seized from the school till 7/1/2026, and except recording the statement of the complainant, there is no progress in the investigation. And considering this aspect of the case, the other co-accused persons were already granted the privilege of pre-arrest bail by the learned additional session judge. Mr. Botapur further submitted that from the CD also it reveals that after 7/1/2026 there is no note of the IO and there is no such progress of the investigation except recording the statement of the complainant. Accordingly, he submitted that updated case diary may be called for with a direction to IO to proceed with the further investigation of this case. Next part, considering the sufficient other aspects of the case and also considering the investigating so far done by the officer, this court is of opinion that an interim protection may be provided to the present petition so that he can appear and can cooperate in the investigation of this case. Next part, CD to updated CD corporate and Baki interim protection. Yes. We're calling the updated case diary.
Yes.
Direction with a further direction to the IO to proceed with the further investigation of this case. Okay, you will be under interim protection. Appear before the IO, record your statement, and cooperate in the investigation. Yes, when it can.
5th of May.
5th of May.
5th of
5th of May.
May please hold. Here I am appearing for a respondent notice. The appeal against acquittal.
Oh, you have already appeared.
We have also filed our objection as regards the leave matter. Leave is yet to be allowed.
Leave is yet to be allowed. That's why the IA is there. So you have filed your objection.
Lordship.
Basically, what nature of case is this? NI?
138 NI, my lord.
NI
What
case.
happened in this case? Law point is involved, my lord. Question of law. That the case was not filed by the payee of the check. Payee of the check was Veteran Security Service, my lord. And the case was filed by one Deepak Chakraborty. And during the course of the trial, the same Deepak Chakraborty failed to show any nexus to that particular payment. Veteran Security Service. The learned trial court, while appreciating the materials on record, overlooked this aspect of the case and convicted the respondent. And thereafter, the respondent preferred one appeal before the learned court of session. In the sessions court, this aspect came into light. The entire matter was considered, accordingly, the appeal.
You got the acquittal. And appears for the applicant, Mr. Peters. Is submitted by Mr. Peter. That is basically no points basis of which the appellate court passed the order of equity in favor of the present. After we cannot fix any data.
I think on last occasion also they did not appear.
Yes. It none of it. After list after 2 weeks as an date to be by the registry. However, in absence of the petitioner, oblique applicant, the consequential order may be passed.
CPOB.
Applicable.
Yes.
Lordship, this matter may be kindly taken up tomorrow, Lordship. Lordship, what happened, Lordship? There was a report called for Lordship, which was not present in the morning, Lordship. Later on, he got the letter, but my senior left already, Lordship, for some personal inconvenience, Lordship. Tomorrow, Lordship.
What kind of report it was?
Whether in this case, article submitted or final report submitted.
Oh.
My instruction will put
Tomorrow when it's not at all possible.
It will not take much time, Lordship.
No, timing is not there. Already its list is over and we cannot fix it as a supplement. Either maybe 30 or first. That apart we can. The request made by statement 30.
Yes.
Report will keep.
yes, but that will be kept as part.
Report is already received from officer in charge, Sangsari police station. Keep the report as part.
IA is fine.
What is the IA for?
Lordship.
Condonation or what?
Yes.
Condonation.
The finding is here.
482 days. It's a long delay. So there are 6 private respondents. Have you issued notice?
Yes, sir.
Have you taken steps?
Yes, my lord. That's why the conditional delay is filed, and for the purpose of issuing notice, also it make the claim. Pleading is for the issue of notice and also for condemnation of delay. One is 480 days since the date of
No,
dismissal
for
of
482 days, matter has to be condemned. Otherwise, you're connected with.
It is not yet reached.
Not yet raised. No, you have not taken steps for issuing notice also. Issue notice. How? Because there are. It seems there are 6 numbers of private respondents. No, I don't know whether there is 6 numbers. I know we issuing notice only. State 9. Oh, sorry, state is not a party, na? You are Mr.
A Bhuya.
Huh?
A Bhuya.
A Bhuya. Your name is here? You are appearing for Mr. K.R. Boru or what?
Yes.
Or Mr. A Bhuya appearing on behalf of Mr. K.R. Boru and the applicant? From the office note, it is seen that no steps has been taken. You go the out. Issue notice to the all respondents to speed and mutual. List the matter accordingly after 2 weeks as on a date befit. 3 weeks as on a date befit. You take steps immediately. We're listing it after 3 weeks. Then report may come. Yes, 35. This is also with filing number.
Lordship.
What was the delay?
794 days, Your Lordship.
794. Yes, Mr. Sharma, have you filed any objection here?
Till now, no objection.
Are you going to file or you're
going
for submission?
I'm going.
You'll be filing?
Yes. Oh,
Explanation. It is also a case of a NI.
NI.
State is a formal.
Ranjit.
Heard Dr. P.N. Gokul, the learned counsel for the petition. So heard Mr. S.J. Sharma for appearing for the respondent number 2 and Mr. P. Botakur, the learned counsel appearing for the state respondent number. It is submitted by Mr. Sharma. Time may be given for filing their written objection against the petition for confirmation. How many weeks you need in that case? Is there any, how many weeks you need for filing your objection?
Come after vacation.
That will do. Date you require date or after vacation will? After vacation. This matter accordingly immediately after vacation as on a date to fixed by the registry, enabling the respondent number 2 to file their written objection. In that case, if you suppose you not file any written objection, make a verbal oral submission will, because there may be some reasons for delay. You have already cited the grounds of a delay.
37.
May I please your lordship? Lordship, I take your lordship to an order passed by the my lord.
Your lordship may kindly fill office note that is
And the office note is there.
Office note, my lord, only my lord, that my lord, scan copy is here before your lordship. Office note with regards to respondent number 2, my lord. That may not be necessary because respondent number 1, my lord. That may not be necessary. Why, my lord? The respondent number 1 has, my lord, stopped operating the account of the petitioner only because of at the instance of the my lord respondent number 2. So, my lord, lordship will consider whether the further continuation of the petitioner's, my lord, stopping of account, operation of account money is necessary, my lord. On the face of the record, lordship kindly see.
He is the branch manager, na?
He is the branch manager. My lord, what happened in this case?
No, we'll not going to hear the matter. Now, question is that as per the office note, the notice is, service is still awaited for the respondent number 1. But this is a bank manager. How service can be awaited?
We have taken steps.
We have taken steps.
Yes.
No, that's what I'm asking. How service can be awaited, Mr. Botak?
We have taken steps.
Because he's a branch manager. Branch manager by name not is there, not?
My lord, why I have made him party? Because, my lord, at the instance of the, my lord, respondent number 2, my lord, the operation of the account was stopped, and she is a beneficiary. She's living separately now from her husband. Her husband is an accused. No, my lord, allegation against her, my lord. Only allegation is that, my lord.
What kind of thing is this? For quashing?
My lord, not my lord.
Your petition is for quashing or what?
Not my lord.
accounts of the
My lord,
defreezing.
Defreezing, my lord. Defreezing only, my lord. My lord, lordship.
Yes, you are going to hear the matter. That apart for the defreezing, most probably your scan copy will be required. Is it here?
Yes, this is here, my lord.
Scan copy already received.
Yes, this is here. My lord, next
So
Tuesday.
if you want to
Yes, my lord.
delete the name of respondent number 1.
Yeah, yes, my lord.
It's up to you.
Yes. I pray for that at this stage. Not a necessary. I just made a party because once, if it is open, then my lord.
Your name is not reflected.
And page.
Your name is not reflected in the clause list. 37 no, Janet.
Yes, my lord.
Your name is not reflected.
Reflected, but in Ukalatama, my signature is there, my lord. Unfortunately, my name, my juniors are there, my lord.
You are Mr. J.M.
Chaudhary. Lordship.
You have filed your wakalat.
Yes,
Part Mr. J.M. Chaudhary, the learned counsel for the petition. So part Mr. P. Botakur, the learned petitioner. As per this note, dated 23/03/2026, neither the ID card nor the answer notice in respect of the respondent number 1 has returned back at the section till date. But one thing, Mr. Chaudhary, if he will not be in the party because suppose in case any direction has to be given by the court for defreezing, let us see. In that case, how
that will suffice the purpose then.
No, we are not purpose serving or purpose. I'm not talking about. I'm just talking about. Suppose in case defreezing order is there, if you want to delete the name of the respondent number 1, then it in case it may create some problem. That much only.
My lord, the respondent number was has nothing to do. Only thing is that respondent number 1 has
Nothing to do. We are not on that. As per you are saying that officer in charge made the court to pass an order for defreezing the
Yes,
account.
ma'am.
That is okay. On that basis only, this account has been freezed.
Yes.
I mean, accounts have been freezed. Now my question is just suppose defreezing order is there. Suppose.
Yes.
May not be. I don't know.
Yes. Yes.
So in that case, order has to be complied by the respondent number 1. So
No,
will it
no, my
be-
lord. Lordship kindly see page 35 board.
No, 35 is okay. Who will comply the order?
The order will be passed by the special judge Dimahasau.
No. Defreezing order will be complied by whom?
Complied by
By the bank
manager.
only. That's what I'm asking.
In that
If
case, my
suppose
lord,
in that case his presence may be required or may not be, you think over it.
yes,
And then you just submit.
lordship.
Or
In that case, what I will do, my lord, I'll survey my lord dusty service upon the respondent number 1.
Honesty is to not allow through concerned police station. You can his address is
Address is my lord Bodorpur.
Borderpur. So OC which concerned police station can be addressed.
My lord, it also he can.
He has not taken. He has taken steps.
Steps
through
are
speed
taken.
post. But notice.
Since
it was done through AD only.
Yes.
Why AD? Nowadays to speed post only.
Yes, that order was there. That is why. So, my lord, what I'll do, my lord, this is a public office, my lord, bank. I'll serve a copy of the writ petition along with annexer to the my lord branch manager.
It's not a writ petition. It's a criminal petition.
It's a criminal petition.
That's what.
Along with criminal petition, I'll serve a copy to the my lord.
Through dusty is not possible. Through OC concern you can. Heard Mr. GMH was so and so. Presented not in that view. The petitioner is hereby directed to issue notice through speed post as well as through officer in charge of the concerned police station. Petitioner will take it within 2-3 days. PCR has already been received. Listed accordingly. Yes, how many weeks you need?
After a week, my lord.
A week. How?
By this week we'll take steps. Tomorrow we'll take steps. My lord. By speed post it will take 3 days to 4 days.
Then 3 days to 4 days. Then how it will be on second week, next week? Let it be on
20th, my lord. After vacation.
After vacation. 20th is a holiday or
no, my lord, Monday.
Monday. Okay, then 20.
Then 21st is the my lord Tuesday. This will be better, my lord.
21st? Okay.
21st.
Your name, I will pass a direction.
Yes.
Registry is also hereby directed to reflect the name of the JMH Chaudhary in the course of the next date.
Oblige.
My lord.
CD received?
No.
CD not received. Where from it has to come? Huh? Then issue reminder because there is no interim also operating and interim cannot be there also because case is under investigation only. Anyway. You are MS?
RDEC.
RDEC. Mr. Chaudhary is not today available today.
Yeah. He's not
He's gone to his hometown.
No, Lordship. He is on port 5.
Port number. RMS RDEC. permits to be bought only be bought submitted for CD notice should remind directing the IO to furnish the CD on or before institute. Yes, when it can be on interim is not operating, let it be
Short date maybe
short means basically maybe after being
on week of before vacation. No.
before vacation possibility is there or what? If it is there, then
Any date, Lordship, before vacation.
He is already protected.
in that case,
Who was acquitted earlier?
yes, yes, that was the
Yes, in an earlier case, he was
Acquitted,
not
Lordship.
and thereafter again after acquittal,
yes. This time some systematic allegations are there. Yes. 29 may be a bit long.
Yes.
So can it be on 2020?
Yes.
April, Lordship.
Obviously April to this month we don't have any time. And you see from 9th of April till 19th most probably these are all holiday.
Yes, 9 and 10 is a holiday.
9, 10 holiday, then holidays. That's it.
Yes.
Immediately after vacation, it may not reach also.
Let's start.
You also going for Bihu, I
Yes, yes.
Then, for considering your aspect only, we are not fixing. Where from you are?
Nalbari, Lordship.
Nobody. Waterkur is from where?
I am from actually my place is my Mutrapur, nearby Sonari, University.
Oh, Sonari.
Shivsagar district now, my
House. Your hometown is in Sorai.
My place name is Mutrapur.
Now Soraido, Nazira is becoming very famous for one.
Between Nazira and Sonari.
Ah. Ah. From Shivsagar to Nazira, Soraido, it takes we've been there in the last 2-3 weeks back, I think. Shivsagar, Soraido, and then Nazira also.